We will now observe a minute of silence.
Muito obrigado. Podem sentar.
Thank you. You may sit. Ladies and gentlemen, honorable members of parliament, under Article 38 of the rules, I have the honor to invite our guests to come to the chamber. I will invite His Excellency Ambassador Maria Antoinette Rose-Quatre from MARP to come to the chamber. She's not around. I will now invite Mr. Alex Musond, Director of the Working Team for Southern Africa, for a message.
Convido o consultor professor.
I will invite Mr. Marius Oliver to the chamber.
Convido a senhora secretária-geral para
Invite the clerk to read the agenda and presentation of the model law on labor migration in Africa and human rights in Africa. Clerk, you have the floor.
Honorable President, after the confirmation of quorum, the business of the day is the first order of business for the day is presentation and adoption of the model law on labor migration in Africa. The presenters, Honorable John Bons Bideri, Chairperson of the Committee on Trade, Customs and Immigration Matters of the Pan-African Parliament, Mr. Alexio Musindo, Director, Decent Work Team for Eastern and Southern Africa of the International Labour Organization, and Professor Marius Olivier, a consultant. Thank you, Honorable President.
muito.
Thank you, clerk. Before giving the floor to the chair of Committee on Trade, Customs and Immigration, Honorable John Bonds Bideri, I would like to indicate that the process for consultation of this model law was performed in all regions, and we had the participation of civil society, of national parliaments, and we also had the support from experts in this subject. So this is a law that will help us to guide us in terms of labor, migration, and also human rights in Africa, which is a situation that is a concern to us in our continent, and we need to create laws. And in this sense, I will now invite Honorable John Bonds, the Chair of Committee on Trade, Customs and Immigration Matters, to make the presentation of the model law. You have the floor, Chair.
Honorable Third Vice President of the Pan-African Parliament, members of Parliament, the clerk, deputy clerk, and staff, our consultants, I would like to take this opportunity to present to you the processes that we have gone through in the formulation of the model law on labor migration in Africa, which took quite a bit of time, but eventually it is here. Labor migration is a defining feature of Africa integration and socio-economic transformation. Every year, millions of Africans move in search of employment and decent livelihoods. However, national laws governing recruitment, social protection, and mobility remain fragmented. Migrant workers often experience discrimination, unsafe conditions, and weak access to justice. The deplorable and worrying situation of migrants, including migrant workers in many host countries who are reported to face violations of labor and other rights of migrant workers, xenophobia attacks on migrants, and arbitrary expulsions highlight the challenges to achieving decent work, equal treatment, and the protection of human rights, including labor rights. In accordance with African Union instruments, RECs, and international instruments that many African states have ratified. Recognizing these gaps, the Pan-African Parliament, by resolution taken in November 2022, adopted during the first session of the Sixth Parliament on 10th November 2022, resolved to initiate the formulation of a continental model law on labor migration that would serve as a legislative blueprint for member states in addressing labor migration challenges. The resolution was adopted in fulfillment of the Pan-African Parliament mandate and Article 17 of the Constitutive Act of the African Union and Article 11, Subarticle 3 and Subarticle 7 of the Protocol to the Treaty establishing the African Economic Community relating to the Pan-African Parliament. Spearheaded by the Permanent Committee on Trade, Customs and Immigration Matters, the model law on labor migration in Africa, as tabled before this August plenary for final adoption, is a significant stride in promoting the rights-based, fair, and coordinated labor mobility across the continent. It responds to persistent challenges surrounding the protection of migrant workers, the absence of harmonized legal frameworks, and the need to strengthen the developmental impact of migration for both the formulation process. In line with the Pan-African Parliament guidelines on the formulation of model laws, the process of developing model laws on labor migration in Africa was highly consultative and collaborative. It was led by the Committee of Trade, Customs and Immigration with technical support from International Labour Organization and technical inputs from various relevant international, regional, and national institutions, such as the International Organization for Migration, the African Union Commission, GIZ, regional economic communities, and African civil society organizations, and legal guidance from the Pan-African Legal Council. The broad coalition ensured that the model law aligns and draws inspiration from AU legal and policy instruments such as the African Charter on Human and People's Rights and its protocols. The protocols to the treaty establishing African Economic Community relating to free movement of persons, rights of residence, and right of establishment. The agreement establishing the African Free Trade Area, the African Union Convention on Cross-Border Cooperation, AU Free Movement of Persons Protocol, the Migration Policy Framework for Africa, and many others. From inception to finalization, the model law has followed the PAP standard lawmaking roadmap, which I'll not go through. So overall, the process of formulation of the model law was evidence-based and participatory, involving meaningful continental and technical consultation with representatives from ministries of labor, national and regional parliaments, employers and workers organizations, African Union, regional economic communities, and international institutions, academic experts, and civil society groups. Throughout the process, the Pan-African Parliament Legal Council ensured that the model law maintained legal and policy coherence with other African Union instruments, as well as other Pan-African model laws, including those on policing, cooperatives, disability, and food and nutrition security. Now, the rationale and objective of the model law. The model law is premised on the recognition that labor migration, when governed equitably, can contribute to national growth, regional integration, and sustainable development. However, the absence of coherent legal and institutional frameworks often leads to irregular migration, human trafficking, xenophobia, and the denial of social and economic rights. Therefore, the overarching aim of the model law is therefore to provide member states with a harmonized human rights and legislative framework for managing labor migration, and its specific objectives are to ensure the migrant workers enjoy, with some exceptions, the equal labor and social rights as nationals, facilitate safe, regular, and orderly migration and mobility for work, promote the portability of social security benefits across borders, eliminate exploitation and unfair recruitment practices, encourage bilateral and multilateral cooperation on labor migration, and support the domestication of relevant AU and international conventions and standards. In addition to its normative goals, the model law also serves as a development function, positioning migration as a lever for achieving Agenda 2063, the Africa we want, particularly under Aspiration 1 and 6, on inclusive growth and people-driven development, and it underscores the interlinkages between migration and employment, gender equality, and regional integration. The structure of the draft model law will be discussed by the consultant, as well as the substantive highlights. You'll have the opportunity to go through them. And therefore, what is the way forward and recommendation to the plenary? From the foregoing, the Committee of Trade, Customs and Immigration Matters now submits the draft model law on labor migration in Africa to the plenary with the following recommendation. 1, that the plenary approves the draft model law on labor migration in Africa as a PAP legislative instrument. 2, that the adopted model law be transmitted to the African Union and the member states for use and adaptation in national context. 3, that the Pan-African Parliament continues to support the committee with the AUC, ILO, IOM, REX, and other relevant stakeholders to promote domestication, awareness, capacity building, and technical and policy support on the model law. 4, that each Pan-African Parliament national delegation be mandated to spearhead advocacy within national parliaments to facilitate domestication or domesticate adaptation of the model law. That the plenary, as I conclude, that the plenary actually expresses deep gratitude, first of all, to the leadership of the Pan-African Parliament that mandated the committee to go on with the processes. I also wish to thank the partners, including the AUC, ILO, IOM, REX, government representatives, academia, trade and business unions, and civil society, whose invaluable contributions shaped the structure and content of the model law. A special mention should go to ILO, whose material and technical support made possible the holding of consultations and the finalization of the model law. I would also wish to thank the members of the Secretariat, especially the committee staff, as well as the legal advisor from the Pan-African Parliament, whose administration and technical legal support, respectively, were instrumental in the processes of developing and finalizing this model law. Last but not least, my fellow members of the Committee of Trade, Customs, and Immigration Matters, for their unwavering support and active engagement in all stages of the formulation of the model law. The Committee on Trade, Customs, and Immigration, therefore, respectively submits the draft model law to the Honorable Plenary for consideration and adoption. Its endorsement will mark a defining step towards an Africa where mobility is safe, dignified, fair, and beneficial for all, and constitutes a true driver of continental integration and economic development. One Africa, one voice, I submit.
Muito obrigada.
Thank you, Honorable Chair. A round of applause, because this is an important day for the Parliament, and this is an important model law, and after the presentation by the chair of this committee, Honorable John Bonds, I will now give the floor to Mr. Alexio Musindo to make his presentation. You have the floor.
Thank you very much, Madam Vice President, honorable members of the Pan-Africa Parliament, Excellencies, distinguished guests, ladies and gentlemen. It is an honor and pleasure for us from the ILO to join you today at this historic discussion of the model law on labor migration in Africa. A milestone achievement that underscores Africa's collective commitment to fair, safe, and dignified migration for all. On behalf of the International Labour Organization, allow me to commend the Pan-Africa Parliament for its leadership and vision in advancing this crucial framework. The achievements reflect not only the Parliament's dedication to workers' rights and social justice, but also its determination to translate continental aspirations into practical instruments that improve people's lives. The ILO is pleased to recall that the ILO Pan-Africa Parliament Partnership that was launched in 2021 was established to enhance fair and effective labor migration governance in Africa, a key area of cooperation under the joint ILO-PAP action plan. This cooperation has been grounded in a shared conviction that labor migration, when governed effectively, can be a powerful driver for inclusive growth, regional integration, and sustainable development across the continent. Over the years, several policy and legal frameworks have been developed at continental, regional, and national level to strengthen labor migration governance. At the continental level, the African Union Commission has adopted several landmark instruments, including the Migration Policy Framework for Africa, the AU Free Movement Protocol, and a range of declarations and guidelines promoting the protection of migrant workers, the development of bilateral labor migration agreements, and fair recruitment practices. Significant steps have also been taken by regional economic communities, which are increasingly integrating labor migration governance into regional agendas. At the national level, more and more countries are developing national labor migration policies, reflecting a growing recognition that mobility and labor rights must be governed coherently. Despite these commendable efforts, it is within this context that the Pan-Africa Parliament embarked on the drafting of the Model Labor Law on labor migration in Africa. This initiative, several years in the making, as explained, embodies a collective vision that fair and effective labor migration governance is essential to achieving decent work and social justice for all in Africa's broader development objectives. The model law represents far more than a legal or policy instrument. It is, above all, a commitment to people, to the millions of African men and women who cross borders in search of opportunities, to the families who depend on their remittances, and to the communities that thrive on their skill, labor, and innovation. Today's discussion could not have been more timely. Across Africa, labor migration is part of our shared story. Migrant workers make invaluable contribution to the economies and societies of both their countries of origin and their destination. And yet, too often, their work is undervalued, their rights are insufficiently protected, their voices are unheard. The model law offers an ambitious yet practical framework to change that reality. It provides guidance to member states on designing inclusive, rights-based, and gender-responsive labor migration policies. It supports governments in aligning national laws with continental and international standards, ensuring that labor migration takes place under fair recruitment systems, safe working conditions, and with adequate access to social protection. From its foundations, the ILO has placed the protection of workers, including migrant workers, at the heart of its mandate. Through the setting and provision of international labor standards, the ILO provides the normative foundation for fair labor migration governance. These standards, developed through tripartite dialogue amongst government, workers, and employers, are crucial for safeguarding rights, preventing exploitation, and promoting equal treatment for all workers. Last year, 2024, we celebrated the 75th anniversary of the Migration for Employment Convention, what we call Convention 97, and its accompanying recommendation number 86. This year, 2025, marks the 50th anniversary of the Migrant Workers Supplementary Provision, Convention number 143 and Recommendation 151. Together, these two instruments remain central to ensuring that migrant workers are treated with dignity and fairness, and that migration serves both development and social justice. Despite this progress, the rate of ratification of these conventions remains low. So I take this opportunity, Madam Vice Chair, to urge all member states to intensify efforts to ratify and implement these standards, ensuring that national laws and policies fully reflect their spirit and purposes. Honorables, when migration is well governed, it becomes a powerful driver for human development. Migrants bring skills, innovation, and resources that enhance productivity and strength to communities. Remittances improve access to education, health, and livelihood. And circular migration facilitates knowledge transfer and technology exchange, contributing to economic diversification. However, to harness these benefits, migration again has to be safe, regular, and fair. The model law that will be discussed provides the enabling environment for this vision, laying ground for member states to develop coherent legal and institutional framework that protect migrant workers, strengthen bilateral and regional mechanisms, integrate labor mobility into broader economic and development planning, and promote gender equality and social inclusion in migration governance. This development is a testament of partnership between the Pan-African Parliament, the African Union, the ILO, and IOM, and numerous knowledge institutions and technical partners, as well as governments. As we move into implementation, these partnerships become even more critical. Together, as partners, we can ensure that this model law becomes a living instrument that not only shapes laws and institutions, but also transforms lives and livelihoods. As we look into the future, we must remember that migration is not a challenge to be managed. It is a human reality to be embraced and governed wisely. Beyond aligning with international and continental standards, it is vital to ensure policy coherence across related areas. Labor mobility is key enabler of trade, investment, and economic integration as envisioned under the African Continental Free Trade Area. The African Union Free Trade Movement Protocol complements this vision. Together, these frameworks reinforce the goal of an integrated, prosperous, and peaceful Africa. Let me conclude by congratulating the Pan-African Parliament and all partners on this remarkable achievement. The model law is a promise of dignity, fairness, and opportunity for millions of Africa. On behalf of the ILO, I wish to express our sincere appreciation to the Pan-African Parliament and the African Union for entrusting us as a technical partner in this important initiative. We are deeply honored to have accomplished this process from its inception to where we are and reaffirm our continued technical support and partnership as we move forward. With these remarks, honorables, I do thank you for your attention.
Muito obrigada.
Thank you, Mr. Alessio Musinda, representing ILO, for the presentation and also for reminding us about our roles as MPs and what is also enshrined in Article 4D of our rules. And explained our mandate and our mission as MPs, which is to work to develop model laws as the legislative arm of African Union. Migration is an important theme for Africa, And we have seen every day the situation of migration without being regulated, which contradicts our mission and ambition of having free movement of people in our continent, and also to ensure access of dignified labor. And it makes sense, as the chair of the committee said, that we should have this model law. So now I'll give the floor to the next speaker, Professor Marius Oliver, for his presentation. Thank you.
Honourable Vice President, honourable members of Parliament present, the Director of the ILO, other excellencies, ladies and gentlemen, it is my privilege to present to you a kind of a summarized version, if you like, of the draft model law on labour migration in Africa. May I, in the first place, express my thanks to, in particular, the Pan-African Parliament Committee that has been involved with this on trade, custom, immigration matters, the Secretariat of the Pan-African Parliament, in particular also the Legal Council has been closely involved in the whole process, the ILO, who has been very much involved from the beginning and very supportive also for their inputs and guidance, other international organizations that have been mentioned, and also, of course, the experts and members of Parliament themselves who have been closely involved, as I will be explaining within a moment. The model law is a result of numerous sessions that we have had with the committee since, I think, September last year until recently. Also, the previous plenary session about a year ago when there was a first reading of the then version of the law. Then the two expert workshops held in June and in September this year, and the experts involved, and those experts also involved quite a number of members of Parliament of the Pan-African Parliament who diligently participated. Then also to, in particular, the Legal Council of the Pan-African Parliament, who made sure that the law reflects the Pan-African Parliament framework process, requirements, but also substantively that it complies with all the decisions taken and recommendations made by the range of previous sessions. And I must say the ILO specialists involved at that stage acknowledge all of that. So the version that I'm presenting to you is the version as finally considered by the Legal Council and with the acknowledgement of the ILO specialist. Ladies and gentlemen, this is a comprehensive law for reasons that will become evident. As far as the contents of my presentation is concerned, I will briefly talk about the mandate and purpose. Some of this has been reflected on already. Briefly, the process to date. Then I want to say, make some remarks about the normative framework that informed the drafting of the model law. A few words on the structure of the model law, and then of course, the model law in its various parts, starting with a preamble. And part 1, 2, 3, 4, and 5. Part 1 concerns general provisions. Part 2, fundamental rights and obligations of labour migration actors. Part 3 concerns regulation of labour migration. Part 4 on implementation, coordination, and monitoring. And finally, Part 5 on the concluding provisions. The mandate and purpose, as we have been told already, is that this model law is meant to serve as a legal tool and as a guiding framework for AU member states in managing international labour migration in an effective, harmonized, and coordinated manner. Of course, this law has to be domesticated in whatever form the countries would like to have it adopted. So this is purely, as I could use the term, a guiding framework for the countries. The model law combines human rights, but also inclusive of fundamental labour rights and developmental and gender-based approaches, as you will see. It supports concrete action by ILO constituents, Pan-African Parliament and other stakeholders on the promotion and implementation of AU, REX, and international legal instruments and policy frameworks, including but not limited to ILO international labour standards. The process up to date is there was an initial inception report, a first meeting with the committee on 17 September 2024, a drafting of the model law and of the revised legal policy paper that accompanied the draft law at that stage. There was a technical validation at that stage, 30 October last year. Consideration and formal endorsement last year by the committee of the then version. Presentation of the model law to this plenary session last year on 14 November, to be precise. We have incorporated revisions throughout based on comments received from members of the Pan-African Parliament, the AUC, ILO, IAM, and even other experts. The incorporation of the Nairobi and Accra workshops, the feedback and the comments, and lately also of the final session that we had with the committee in September this year. We have seen 5 consecutive draft versions, so what you actually see could probably be seen as the 6th version of the model law. Importantly, since this is a legal instrument, the question arises, where do we get what is the source, or what are the sources of this model law? And I must say, in general, it relates to all relevant labour migration and mobility treaty and non-treaty law from an international perspective. And even so, this is extremely extensive. You have a wide range of UN instruments, a considerable range of ILO instruments, and then at the level of the African Union, the African Union itself has adopted several instruments and frameworks over the years, and that is also the case with many of our RECs, regional economic communities, increasingly so. But there are also the soft law instruments, in other words, instruments that may not necessarily be binding, like UN and ILO guiding instruments, ILO recommendations, UN general comments on a range of issues, and the important global compact on regular labor, on regular migration, the GCM. The treaty law, by the way, refers to human rights instruments, UN instruments in particular, but also labor migration focus instruments. I repeat again, the ILO instruments that are so important, and then relevant free trade agreements, both GATS and then also at the African Union level, the African Continental Free Trade Agreement. ILO general surveys have also been helpful, as is the case with the supervisory bodies of the UN and the ILO and their recommendations. The AU normative framework in particular, since this is an AU instrument, needs to be mentioned. There is the AU treaty law, the Banjul Charter, or if you like, then the Charter of Fundamental of Human and People's Rights of 1981, extremely important instrument that has been interpreted in a particular way also in relation to the rights of migrants and migrant workers. And that interpretation mainly arises from the work of the African Commission on Human and People's Rights, and we have taken all of that on board. Specific AU protocols and their relevant provisions, already mention was made of the Free Movement Protocol, but there are several others too. In fact, almost all of the protocols, most of them have a reference to or impact on labor migration as well. Free movement instruments, integration objectives, quite important in the continent, and that is supported by several instruments like the Abuja Treaty and others. Relevant free trade provisions, as already said. Soft law instruments at the level of the AU, Agenda 2063, the important Declaration on Migrant Workers' Rights, has been especially instrumental and influential for purpose of this draft law. The AU Migration Policy Framework and Action Plan already mentioned. The recently 2022 adopted guidelines on bilateral labor agreements of the African Union. And in the same year, the African Union also adopted Migrant Welfare Program guidelines. So this is a snapshot of some of the, of many but not all of the soft law instruments. And then, of course, there have been several AU commissioned surveys, such as on free movement, on return and reintegration, etc. At the REX level, REX treaties at times make mention of issues relevant to labor migration. For example, the SADC Employment and Labor Protocol of 2023, which is an instrument in terms of the SADC Treaty. The ECOWAS General Convention on Social Security, extremely important. Several free movement instruments of our various RECs. Regional integration objectives flowing from these instruments, but also relevant free trade agreement provisions. There are several, almost all of our RECs have also their own regional free trade agreements. Soft law instruments, already mentioned earlier today, RECs, labor migration policy frameworks and action plans. All of these have been instrumental. So what about the national level? Of course, this is a law that will inform national laws. Now, as you will see on the next slide, is that we couldn't find a single labor migration law which is purely focusing only on labor migration in the whole of the continent. Labor migration is an area that is scattered, if I could use the word, across several other laws, as you'll see within a moment, which of course makes it comprehensive, if not complicated, exercise. Guiding frameworks have been developed in particular, including policy frameworks at many of our countries have been and are in the process of adopting national labor migration policies. Unilateral and bilateral arrangements contained in national laws, in other words, national laws providing for these agreements. And then the arrangement themselves. We have a rising number of bilateral labor agreements even within the continent amongst African Union member states, but certainly a mushrooming number of bilateral labor agreements with other countries outside Africa, and a smaller number of bilateral social security agreements, all of them important. And also importantly, constitutional provisions, not just on labor migration generally, but on the role and place of international law, because that would inform what is the value and the role being attached to the international legal framework in relation to these matters. I said that labor migration is an issue that is scattered across many laws in our member states. And here's a snapshot of the most important ones. You will find in the immigration laws, of course, extremely important provisions. But some countries would have dedicated laws concerning Right, so I've been informed that I have 20 minutes for the presentation, so see what I can do. Immigration laws, dedicated laws of foreign employment, labor laws, social security laws, regulation protection of migrant workers abroad, rights of and obligations imposed on migrant workers, labor migration specific policies, and then at the REX level, as I've said. So, ladies and gentlemen, let's immediately move to the preamble. This is a very long preamble. An extensive range of considerations have been mentioned in the preamble, as you would have seen. Gives you an impression of how extensive this terrain is. But also, in particular, I must emphasize again the valuable guidance contained in the AU Draft Declaration on the Protection and Promotion of the Rights of Migrant Workers. I'm not going to say too much about the purpose provision because that has already been discussed earlier by myself. The scope and the primacy of the law. It covers labor migration to and from countries of the continent and all the essential elements involved. All categories of migrant workers are included, and it addresses the full migration cycle from pre-recruitment up to return and reintegration as well. Definition section is a very long section, as you will have seen, Article 3. We have brought on board also recent developments like in the area of digital labor platform, digital migrant workers, as you will have seen. So those are the definitions. Definitions have been taken from AU instruments, ILO instruments, and other important UN and also IAM guiding frameworks. Right. The interpretation of the law has to be done in accordance with the purpose and the principles contained in the law, but also international regional agreements and agreements to which state parties are indeed party as well. Importantly, without going into detail, a range of guiding principles, and you'll see a very long list of guiding principles. And the reason for this being such a long list is the very nature of labor migration. There are issues such as migration development, rights-based approaches, prohibition of discrimination, decent work and living conditions provisions or objectives, return and sustainable reintegration, knowledge-based and evidence-informed responses. These are just a few. On the fundamental rights and obligations of labor migration actors, and as you will see, there are different actors that have been addressed. First, we address thematically in Article 6, universal human rights and labor rights of migrant workers, and those have been unpacked largely in alignment with the declaration of the AU that I already mentioned. Article 7 concerns the obligations of the state, but Article 8 deals with the obligation engagement of other labor migration actors. Obligation of migrant workers, Article 9, and then distinction between position of migrant workers in a regular, Article 11, migrant workers in an irregular situation. Now, we don't have much time to discuss all of this, but let me just say that the fundamental human rights or universal human rights and labor rights of migrant workers, of course, are well known. We have incorporated them, relied heavily also on the apart from the African Union Declaration, also on the UN and ILO instruments, fundamental rights in the labor context as well. Let me leave it with that. Obligations of the state that the state has, and it concerns an acknowledgement that all human beings are equal, and that applies to migrant workers as well. The obligation of states to implement protective and promotive provisions to make sure that migrant workers can claim their rights in terms of labor migration provisions in the country concerned, and so forth. Other actors involved, and those actors, without discussing them in detail, would include labor recruiters. There is a separate provision on recruitment, as you will see. But also rights and obligations, in particular of employers, of trade unions, and of migrant workers associations. Unfortunately, we don't have time to discuss all of this in detail, but we have unpacked all of this in, in these two provisions, these three, from 7 to 9, those three provisions. Migrant workers in a regular situation, the basic rule in the international law and African Union law framework is that migrant workers who are in a regular situation, sometimes we refer to them as documented migrant workers, they have to be treated on par with nationals of the country concerned. There are a few exceptions. For example, the engagement in public affairs. So as you will have noted, the draft law states specifically that it does not mean that even migrant workers in a regular situation would be able to exercise political rights. That has been explicitly reserved, if the country wishes so, to nationals of the country concerned. As far as migrant workers in an irregular situation are concerned, that's a bit more difficult. And what I mean by that is that you really have to analyze the provisions in the AU instruments and the international instruments to get a good grip or grasp of what is the position, status, and the protection, or even in lack of protection, available to migrant workers in irregular situation. And the main point here is that the draft law says that what is contained in Article 11, that is it. That is the full spectrum of what they may be entitled to, other than migrant workers in a regular situation that generally has to be treated on par with nationals of the country concerned. So, for example, if I could just mention 2 or 3 examples, based on international law, that consideration should be given to make sure that at least migrant workers in an irregular situation has the right to emergency medical care and to basic survival, if you like, basic level of assistance, if I could use the word, and that importantly, migrant workers, are entitled to rights flowing from previous employment. So if they did contribute to the social security system, then they're entitled to have the benefits that would be entitled to them. If they worked and they're entitled to a wage, even if they were there in a irregular situation, they need to be provided with a remuneration that is due to them. And there are many good reasons for these provisions. Part 3 concerns the regulation of labour migration. And this is a long part, many important provisions. Article 12 concerns visas and work permits. And it addresses the fact that it's expected of migrant workers to have a valid visa, and it could be a resident visa, but in particular a work permit to work, and that can be enforced, and non-compliance will lead to certain consequences. It will in fact imply irregular status, as one would think. Then Article 13 on facilitation of labour movement, that concerns a range of provisions such as that countries are expected to facilitate labour movement, and many of our countries increasingly do so. They provide a policy and strategic framework, and this is now the legal framework, if you like, for labour movement also from their particular countries. And you will have noted there are a number of provisions that talk about the pathways that may be available to such, to such migrant workers, and that they may have to, but importantly, there are qualifications that migrant workers, at least coming to the country concerned, may be limited in terms of, in particular, their access to part of the labour market and to certain occupations. They may be requested or required to impart their skills to the national labour force, if you like, and that a quota regime can be imposed as well. So these are very important restrictions that we find in some of our countries already existing. Employment contracts, Article 14, is an absolutely critical provision, and the main basic provision on this is in Article 14.1, which states that there has to be an employment contract. It must be in writing, must be signed, must be communicated to the employee even before the employee leaves the country of origin. And then in Article 14, you'll find a host of provisions aimed at the protection through the employment contract of migrant workers who work, and that the contracts themselves must be aligned to the broader legal framework of the country concerned, to the international standards regime, etc. This contract may not be amended unilaterally. It requires the consent of the migrant worker concerned, and a host of other provisions. Article 15 concerns family reunification. And here the basic rule, as you will also find in Article 14 of the AU Free Movement Protocol, is that it is expected of countries where a migrant worker is in a regular situation to allow, within the framework of the legal context of the country concerned, for family reunification. And then there are several provisions in relation to family reunification then spelled out in detail on Article 15. Article 16 concerns an issue which is of huge concern, not just for Africa, but certainly also for Africa, and that is fair and ethical recruitment. So it embodies principles such as that it cannot be expected of the migrant worker to pay recruitment fees. Normally, in international law, that is seen as the obligation of the employer, that these recruitment agencies would have to be regulated. Usually it happens through a licensed system, and what they have to comply with, some of the basic elements of that are actually set out in the draft model law. A very important provision, and all of this is aimed at the protection, of course, of the migrant workers concerned. And the recruitment obligations actually applies not just to recruitment agencies in both the public and private environment, but also to employers and any other intermediaries that may be involved. Article 17 on loss and change of employment embodies a principle, of course, that employment may be terminated in accordance with a contract or any other reason allowed for by national law. But in the event of a no-fault loss of employment, in other words, loss of employment without the intervention of the migrant worker himself, that there are certain protections that would apply to the migrant worker concerned. Okay, loss and change of, that's loss and change. Then the failure to secure employment and the inability to work due to illness and injury. So again, these are matters beyond the control of the migrant worker, and therefore in terms of, in particular, ILO instruments, there are protective arrangements that we have brought on board to protect, at least for the time being, the position of the affected migrant worker. And if they have permanent residence status, so we are told by the ILO convention, then they are entitled to stay on in the country, of course. Article 19, transfer of savings, earnings, belongings, and remittance regulations provides for the transfer of savings. Article 47 of the UN Migrant Workers Convention, quite instrumental in this regard. And they are detailed remittance provisions, and it's expected of the country concerned to develop a framework for the regulation of remittances, the use thereof, the reduction of remittance transfer fees, and a host of other matters, and specific provisions also, not just in this article, but also on the gender dimension to protect women in particular who may be recipients of remittances or who are required to administer or manage remittances so received. Okay. Article 20 on taxation of earnings stipulates a basic principle that, let me just go back, that as a rule subject to international agreements, migrant workers in a regular situation would have to be treated on par with nationals. But of course, importantly, we have to try and avoid double taxation arrangements. And normally this is done through bilateral agreements. Article 21 is an area that the ILO has, the AU has done considerable work also recently, both in terms of policy framework. It concerns return and sustainable reintegration. Not just is there a right to return, but the development of a policy and strategic framework at national level is provided for in the draft law. The establishment of a national council to deal with issues of return and reintegration, considering the extreme importance of this in our countries. The establishment of return and reintegration fund. Importantly, elaborate provisions on the support that may have to be provided to returning migrants by our relevant countries, etc. Article 22 on skills enhancements and skills recognition, of course, is an important area. Investment in skills is critical for our continent, and that has to be supported in particular with an understanding of the skills need both of the country of origin but also the country of destination, and the role played by labour market information systems, LMIS, and many of our countries are investing in that currently, and linking this to the labour migration sphere, extremely important. This provided for, amongst others, in the draft law, the exploration of opportunities abroad in this perspective, the alignment of curricula with the skills needs, and so forth. Social security for migrant workers is a well-trodden area in terms of our international instruments, several UN and ILO instruments. Even at the AU level, we find quite a range of provisions in this regard. So what it essentially says in the article that if you are in a regular situation, a migrant worker, then subject to international or bilateral agreement, you have to be treated on par with the nationals of the country concerned, such as contributing to a contributory social security system. However, it does not mean that migrants, even in a regular situation, are entitled to non-contributory social security, such as social assistance, subject to the extension of minimal support, even to migrant workers in a regular situation based on the national social protection floors paradigm that may be in place in a particular country. The importance of bilateral agreements to support social security, and the principles that have developed over the years as to what these bilateral agreements and social security terms could and should include. This is an extremely important area and the main avenue for the protection of migrant workers in social protection terms, i.e. social security bilateral agreements. But then we also have in Article 24 bilateral labour and labour migration agreements, also multilateral agreements. In our continent for the moment, we have few bilateral social security agreements, but we have wide range and a growing range of bilateral labour agreements. So the issue here is to see how one could incorporate protection for migrant workers, including social protection, into bilateral labour agreements. And we are fortunate that in the continent we now have guidelines by the AU on bilateral labour agreements, supported also by the guidance framework developed by the UN. Both of these date back to 2022. A very important framework. Bilateral agreement, labour agreements is probably the way to make sure that we regulate the flow, but also the protection of migrant workers. Part 4, the penultimate part of the draft law, has to do with implementation, coordination, and monitoring. Article 25 talks of the institutional arrangements, or talks to the institutional arrangements, monitoring and enforcement. It provides for the establishment of a National Labour Migration Authority, which may be the same body and the body that's responsible for the return and reintegration framework, which we discussed earlier. It's a multi-stakeholder composed body, supposed to be. Its functions are extensive because it's there to support government in the work that has to be done in this regard, also the parliaments and the executive, of course. The importance of regional and international cooperation speaks for itself. National monitoring mechanisms and the need for periodic reviews. Article 26 has to be read with this Article 25. It concerns the important issue of social dialogue and national consultation. So what it does, in short, is to bring on board at least tripartite the tripartite partners, that's government, the official employer organization representatives, and an official trade union federation representatives, must be part of this whole process of driving the national consultation on labor migration. But in addition to this, this provision also opens up this process to, on a consultative basis at least, to other role plays such as migrant workers associations, civil society institutions, and even the public at large, as it should be. Labor migration is very much a public issue, a public context. Article 27 on data enhancement, exchange of information, identification of labor market needs. Some of the issues we have talked to. This article provides for data management system to be maintained and the measures that need to be included as far as that is concerned. Very important is a separate sub-article on the gender-sensitive nature of the data that we need to have for purpose of labor migration planning. The management of a common labor migration database, if you like, sharing information with the various structures and others who have to deal with and react on the basis of the information so provided, etc. Then we have Article 28 on offences. It talks about offences in relation to specific articles, in addition to what a few articles themselves may say. It also provides for the possibility of criminal offences in particular. Then there's a provision, Article 29, on penalties. It talks about liability, also other punitive measures such as an Article 30 on administrative offences and remedies for wrongful actions. Administrative offences can be imposed by, let's say, by the executive authority of a country concerned. It may imply the suspension or revocation of licenses of recruitment agencies, for example, and this is in addition to civil and criminal action. Article 31 empowers the minister, which is the minister responsible for labour migration in a country concerned, to adopt or to issue regulations that will deal with the details of many of these issues. And as we know in practice, this is actually a very important power to be executed by ministers. And the final part, Chair, of the draft model law concerns three concluding provisions. The first is on amendment, repeal, and transitional provisions. It says that if the country level you do amend or repeal the law, that it should not affect entitlements that may have accrued based on the previous version of the law. Should not be retrogressive, and it must contain transitional arrangements as well. Authentic text, it must be, of course, available in a national official language or languages. In case of a conflict in terms of understanding or interpretation, then the English version of the draft model as we have it here would be authoritative, as the draft law says. And importantly, the provision of the translation or the availability of this law also in ways and means and languages that would be understandable to persons with disabilities. Entry into force, that has to be determined by the national authority responsible for the labour migration law. Chair, I thank you. That is all for the moment. I thank you, ladies and gentlemen.
Muito obrigado.
I thank you very much for the exhaustive presentations and a very clear one of what has been the work translated in a proposal led with the 5 chapters and the 34 articles. Now we will open a question-answer session for clarification or an improvement of the documents. To remind you, my colleagues, that This paper will be tabled for approval. After its approval, it will be, if there is any other comments, and then we will supply or distribute to all member states and also to other bodies of the African Union, including the Office of the Legal Officer. And the next summit of the head of state that will take place in February, the PAP president will present this report at the summit so that this must be approved by the head of state summit. To remind you that on February summit of this year, the Executive Council has recommended or has encouraged the Pan-African Parliament to strengthen the work of drafting the law, model law. And today we are gathered here with this proposal for our considerations. And once again, I seize this occasion to congratulate all endeavors or all the commitment of the member of this committee, presided by his chairperson of all and all other members for the hard work, and also to thank the Secretariat and the other legal advisors that they were able, that we could have today this draft law on migration, on labor migration in Africa, which will to give the justice to our migrants. We are talking about brothers and sisters that come from our countries seeking for a better life in other brother countries of the African member state of the African Union. And we as legislators, we have the obligation to work towards to ensure the human rights are respected at the member state which hosts these migrants. And in all member states of the Union, we have the migration situation. So we need to regulate this issue, and the human right must be ensured. And then we have a WAF job. So with this law, we are talking about a WAF job which ensure all right to the all labor migrants. Let me now give the floor. I have a list of people who are. Let me now give the floor to
Deputado, senador.
MP Senator Dasum Kumar Mungatana from Kenya. We have 3 minutes allocated for each member of parliament. Thank you very much.
Tenha a palavra, senhor deputado.
Honorable MP, you have the floor, please.
Okay. All right, it's come back. Thank you, Your Excellency, for giving me the opportunity to take the floor. Your Excellency, the Kenya delegation organized a meeting of students who are taking their studies in Nairobi, Kenya, during the celebrations of the African Day this year. And we realized that so many students are studying from Africa who live there. And I sat there to listen to a testimony where somebody said, I am from Burundi. I've met a person I believe who is going to be my future spouse. We are studying the same degree course, and we intend to set up a family together when we finish university. And that story is true for many of us who studied in university. We know that we met our spouses there. But she said, why is it that in African countries, we are not talking about Europe, African countries, when they are advertising for job recruitment, they say only nationals to apply. So why are we discriminating against ourselves? Now, this is the question I'm putting to the experts and chairman of Labour Committee. Is it possible to include within this law a creative provision that would discourage a discrimination from within Africa, so that if advertisements are made, people can apply? You are training in Kenya, you have the same knowledge, but when you are applying for the job, you are told, because you are Rwandese, you are Congolese, you are Zambian, you are not supposed to apply, and you want to start a life with your spouse. So that's a question I am putting there. My second point is, last week, but one, before we came here, I was raising a question in the Senate about social protection of people who are from Africa, who are working within Kenya. In Kenya, we have the Social Health Authority, which is supposed to be giving universal protection to every person. So every Kenyan is deducted 2.75% of your gross salary, or a minimum of 300 shillings. And if you are not in formal employment, there is something called means testing that you undergo. And whatever your income is determined, you pay 2.75% every month, so that you can go to hospital free of charge. But the process of registration, you have to press *147#, and it will give you that stage number 2, you have to give you a national identification. So I was asking the minister, what happens to the Malawians who are here, to the people from all over Africa, Somalis and everybody who are here in Kenya? How do they get the universal social protection? So I'm going back to the draft and asking, how do we help people? You know, I want stronger provisions to help people as far as health is concerned in particular. Because when you are far away from home and you fall sick and you cannot register even to the social health arrangements within the country, then it becomes very tricky. The minister in Kenya said that this migrant labor, they have to go personally and register with the Social Health Authority. Now, some of these people, they live very far away from Nairobi. I think that there's a problem there. So we need to have stronger provisions to protect our migrant labor when they move to our various countries. Finally, Your Excellency, I wanted to take this floor to commend ECOWAS, because ECOWAS has done a good job. That Ghana-Togo corridor, Nigeria-Ghana-Togo corridor, the movement is better than what we see in the East Africa and in SADC. In the ECOWAS area, you can have truck drivers moving with very minimal documentation requirement. And you have within their protocol the right to come in 90 days, the right to work, and the right to establishment. That means to do business. In East Africa, we have something similar within the Common Market Protocol. But then you find you can come into Kenya, you can go to Uganda, you can go to Tanzania, yes, visa-free, you can go to Burundi, you can go to Rwanda and all these East African countries. But then when it comes to the right to work, getting visa is problematic. It may be shorter in Rwanda and Kenya, but in some of these countries, it becomes very difficult for our teachers to go and work there. I'm a lawyer by profession. It's so difficult to, and it was all over in the news in Kenya. Some of our lawyers wanted to go and represent some of the political figures in Tanzania, and it became impossible even to appear in court. And yet we go through the same training, and some of our people went to train in Dar es Salaam, others came to train in Nairobi, but then it becomes impossible to practice there. Now we are asking ourselves, why are we discriminating against ourselves? Why do we do this to ourselves? And yet we complain when the Europeans, Americans, and those other people out there are becoming difficult. Yet we do the same thing. Why is it difficult in East Africa and SADC to do what ECOWAS is doing? I think we need to learn from ECOWAS that we need to open up, not just visa, but allow the people to come and work. Don't make it difficult for them to remit their money back. Some of these countries, I don't want to mention them. You come, when you are bringing your money in here, you get, open arms, acceptance. They clap for you. They want you to start, and you employ their people here. But when you want to take back money to Nairobi, they give you all sorts of difficulties and just reject when you want to, repatriate your profits. So we need to have the political will. I am appealing that even as we pass this model law, we need to have political will to make sure that this law becomes reality, that movement of labor becomes reality. I thank you, Your Excellency.
I thank you, Honorable MP. Let me call upon my colleagues to apply for the time allocated, because we have other issues to discuss, and this will enable other people that can present their insights. Now, let me now give the floor to Senator Professor Ismail Samata from Somali. I thank you. You have 3 minutes allocated. When it's 3 minutes, I will switch off your microphone.
President, I have just a simple question, which is technical. Last year, I made a request to the Secretariat that these documents should be provided to us, not in the morning where they are going to be discussed, but at least a day early so that we can actually look at them very carefully. We had them this morning. The presentations were brief, and therefore we cannot really give substantive commentary on these fundamental laws that we expect to be applied to all over the continent. So may I appeal to the President and others that these documents should be provided to us either electronically the day before or on paper the day before. Thank you very much.
Thank you very much, Honorable MP, for the question. This is a very important question because it's not possible to discuss a paper that is distributed on the same day. You're right. But I trust in your reading capacity and also on the interpretation of our members. So we will do our utmost so that we can give our contribution to improve the documents. I know that several consulting has been taking place at the regional level, as well as at the member state, but also here at the parliament, that we also held different workshops where MPs participated, even those who were not the member of the committees. But of course, we took good note of your appeal, and it makes sense. Let me now call upon the Secretariat so that in the next model law, because we have a model on gender, on sustainability, on soil, and please try to distribute this paper earlier. Now let me give the floor to MP Hepmore Shindefer from Zimbabwe.
Thank you, Honorable Vice President and distinguished honorable members. I rise today in strong support of the modern law on labor migration in Africa. This is not just a legal instrument, it's a moral, political, and pan-African imperative. African labor migration predates colonial borders. The borders were imposed to divide us, and today they continue to fuel xenophobia, a poison that attacks the heart of Pan-Africanism. Africans are being beaten, humiliated, and treated as strangers on African soil. This is an assault on African dignity and betrayal of the liberation struggles that united our continent. This model law provides a path toward dignity, fair labor mobility, recognition of skills and qualifications, social protection for all African workers, strong regional cooperation, shielding workers from trafficking and exploitation. We must clearly deal with xenophobia and say xenophobia is not patriotism. It is internalized colonialism. When an African attacks another African for crossing an imaginary line drawn in Berlin in 1984, that is not self-defense, it is self-destruction. Skills do not have nationality. When the doctor from Ghana heals in Namibia, that is Africa, healing. When the Zimbabwean teacher educates in Botswana, that is Africa, learning. When the Congolese builder constructs in Zambia, that is Africa, rising. Labor migration is not a threat, it is our collective strength. In my country, Zimbabwe, millions of Zimbabweans have moved across the continent, powering economies through nursing, teaching, farming, construction, and service work. Their remittance sustain families and help.
Senhor Deputado, tenha atenção ao tempo, por favor.
Please be aware of the time.
Eu já tinha lhe dado 1 minuto.
I have given you 1 minute and 32 seconds. Please, you must conclude your presentation. Thank you.
Injustice make one, their remittance sustain families and help stabilize communities. Yet they face discrimination, exploitation, and violent xenophobic attacks. These injustices make one thing clear. Without continental protection, African mobility becomes African suffering. Zimbabwe's examples prove that the value of labor migration and the agents of its modern law, our people are helping Africa grow. Africa must protect them in return. Honorable members, let's adopt this law with a united voice. Let us defeat xenophobia and reaffirm that no African is foreign in Africa. We stand divided, we fall alone. But if we stand together, no force on earth can stop us. One Africa, one people, one destiny. Thank you.
Muito obrigado, Senhor Deputado.
Thank you, Honorable MP. I ask the collaboration of our technicians on the time management so that we can fulfill the time and be more precise, and allowing that the other MP can also give their contributions. Now, let me give the floor to Honorable Madame Esther from Kenya. You have the floor.
Me to begin by expressing my sincere appreciation to the presenters, Honorable John Bideri, Mr. Alexio Musindo, and the ILO, from the ILO, and Professor Marius Olivier. Their submissions have clearly demonstrated the depth, professionalism, and humanity that went into formulating the model law on labor migration in Africa. Honorable members, as we listen to this presentation, one truth stood out. Labor migration is not only about mobility, it is a test of leadership, governance, and dignity. Across the world, we see worrying signals that should guide our deliberations today. In the United States, long regarded as the father of democracy, we have seen attempts to roll back equal pay protection and aggressive deportations through ICE of immigrants who have lived and contributed to the economy for years. When global powers normalize discrimination against migrant workers, it creates room for leaders in other regions to adopt the same harmful approaches. We saw this anchored in Brexit, where Africans and Eastern Europeans laborers were blamed for economic and social pressures without acknowledging the tremendous value they add to healthcare, agriculture, industry, and taxation. And closer to home, during the recent Tanzanian elections, The blaming of Kenyans for demonstrations created fear and uncertainty among migrant workers who were legally living and working there. Overnight, communities who had done nothing wrong were viewed with suspicion simply because leadership needed a scapegoat. These examples remind us that migrant vulnerability often begins not at the workplace, but in political rhetorics. The model law must therefore protect migrant workers from exploitation, but also must not only protect migrant workers from exploitation, but also from xenophobia, scapegoating, and discriminatory leadership. Colleagues, we must also reflect honestly on the root causes driving Africans to seek work across borders. Across our continent, corruption and poor governance are shrinking the job market, fueling unrest and undermining public confidence. When opportunities disappear at home, our young people cross borders out of desperation, only to face rejection where they should find opportunity. If we're serious about the promise of Agenda 2063, then we must commit to a zero corruption policy, maximizing Africa's resources for Africa's development, job creation through value addition and manufacturing, clustering economies across the region so that countries' strengths contribute to prosperity.
Mais minuto.
1 more minute, please. 1 more minute.
Economies across regions so that the country's strengths contribute to the prosperous continent. Migration should be a choice rooted in opportunity, not in consequences of governance failures. Honorable members, this model law gives us a chance to set higher standards, one where Africans are protected wherever they go, and where leadership across is accountable for the safety and dignity of those who cross. Let us adopt this law not only as a move with the times, but also to move Africa forward, where every African can say in every African country, I am home. Thank you, Madam Speaker.
Muito obrigada, senhora.
Thank you. In terms of methodology, I would like to suggest the following. The interventions up to now are generical interventions. And I would like to suggest that I will suggest to the colleagues that will come, if you have an observation on an article, they should cite that article so that the consultants can take notes. If you have comments related to any change of article, so that we can note down this information, you should cite the article. And I would like to thank for the contributions which shows the importance of this document. I'll now give the floor to Mr. Mohamed Oussouf from Chad. 3 minutes, please.
شكرا. أشكر المكتب واللجنة لتقديم هذا المشروع.
Thank you very much. I'd like to thank the committee for the hard work done on this model law on labor migration in Africa. It's a model law that is extremely important and that is focused on the aspirations of the African people. And in the preamble, we need to be clear that this model law covers all legislation and jurisdictions to protect the rights of migrant laborers in Africa. And we are in need of a model law that is going to assist us in helping to organize the stay, the working conditions, and the living conditions of migrant laborers so that it is a positive experience for them, so that there is protection and that it is good for the development of Africa. I have a question for the experts who presented. I would like to know what is the percentage of migrant laborers amongst those who leave Africa in the brain drain, and how can the adoption of positive labor legislation how can that have a positive effect on this brain drain? Is there a way of having laws that will prevent the brain drain or prevent the loss of certain key skills? And we have students in our country who organized a meeting where the Minister of Labor was invited, and they held discussions on the fact that many young graduates are leaving. Graduates with degrees in our country are leaving to rather go and work as a driver or a manual laborer in another country. Thank you, Madam President.
Deputado, passa a palavra à senhora deputada Amin Ali Idris de Chad. Tenha bondade.
Bismillahirrahmanirrahim. Merci, Honorable President.
President, for giving me the floor to express myself on this presentation. Honorable colleagues, good morning. Allow me, first of all, to commend the work done by the Committee on Trade on this model law on migration and labor in Africa. I also like to use this opportunity to urge you to do more so that if we adopt it today, it will be of service to our African young people. We all know what the young people in Africa are going through today: unemployment, precariousness, forced exile, and sometimes they even die. We can no longer close our eyes. Today, we have to act quickly and efficiently. If we adopt this model law today, I think that the very important stages are necessary for this law to have an impact on African people. First and foremost, I like to propose that the most urgent thing is to domesticate the law in each member state. For example, in Chad or Ghana could quickly incorporate these texts to guide the incorporation of their technicians so that they can work in other African countries without being facing the risk of exploitation. Secondly, I like to say that we need to set up an African professional mobility mechanism. For example, a young Senegalese IT technician could go work in Kenya, Rwanda, or South Africa on a digital project with their certificates that is automatically recognized with by providing him a simplified visa. Thirdly, we have to invest in training and youth employment. We set up regional centers. I think this exists already in some other countries like in South Africa and Ethiopia. And these centers can help these skilled young people. One more minute, please. So we'll protect the rights and dignity of migrant workers. a migrant worker in Morocco, for example, should benefit from social security. We need to set up an African fund for emergency fund for migrants in distress. Fifth, we should set up a continental monitoring body. For example, an African Migration Observatory that can publish statistics on migrant workers every year, the working conditions, and the success of mobility programs. Dear colleagues, would not like to adopt a model law that will not be followed up on. Would like a law that will transform the lives of Africans. Let us make this a turning point for our young people and for Africa. Thank you very much.
Muito.
Thank you, Honorable. Before giving the floor to the next MP, I would like to invite I will ask the protocol to invite our guests of honor that are present in the lounge to come to the chamber. And I will invite Honorable Lieutenant General, Mr. Michael Rubin, the Senator from Zimbabwe,
Depois da instalação.
After this, we will resume to our list, and I'll give the floor to His Honorable Fatou from Algeria. You have the honor.
السلام عليكم ورحمة الله تعالى وبركاته. مرحبا بالجميع. السيد الرئيس رئيس الجلسة.
To everyone, Honorable President, dear colleagues, members of the Pan-African Parliament, we are discussing a very important law on the human dignity, a law on migration and labor. Africa is facing challenges on humanity and labor. Young people from Africa seeking work in other continents. We are living at a time when migration has become a challenge that cannot be compared with security, but to the social economic work in Africa is very important because we have a lot of energy, and how can we make use of this law? Honorable President, discussions in this plenary, the aim is to look at the spirit of this law, not to look at the articles and the rules of this law. That's where the importance of this law lies. It is implementation on the field in African countries. Can this law provide free movement and unemployment in the labor market? Can this law protect the rights of migrant workers, their families, their dignity? Can this law strengthen the sharing of capacities or skills for sustainable development? Can this law prevent illegal work? And can this law unite all national politicians or policies that seek to unite Africa? Honorable MPs, this law has to lead to free movement of persons recognized by the African Union. a labor market in Africa that can use the energies of our young people instead of struggling to find their debt. My country, Nigeria, that I love, put the person at the center of its policies and believes that development in Africa can only be achieved through unity and cooperation among peoples. This law has to be a law that can lead us to the dignity of workers. Our slogan for a fair Africa, for an Africa that benefits from the efforts of its children. Africa is for Africans. Africa has provided civilization to the world. Africa deserves its place thanks to these young people, these young migrants. We are discussing the future of Africans, these young people who left to seek employment elsewhere for their survival. They seek work in other countries. Africa is not poor. It is rich in energy, but due to these policies that make them lose their energy and put these migrants before very tough challenges. This law should actually free the labor market and should not be a wall or an obstacle between African countries, and Africa has to speak loud and clear as regards the protection of labor. Thank you very much, Honorable President.
Thank you, Honorable MP. We are here trying to transpose in articles what we want for migration in Africa. I'll now give the floor to Honorable Rodney Shwele from Namibia.
President, honorable members, thank you for the opportunity. I want to support this model law on labor migration as a member of the Customs, Immigration and Trade Committee. We talk a lot about African integration, but we act as 54 separate projects, each choosing the same donor approval. No continent develops that way. Integration begins when we trust one another enough to let our people work across borders without treating them as suspects. Honorable President, this model law on labor migration is not about sentiment, it's about management. Labor will move with or without policy. The question is, do we manage it to build our economies, or do we let it manage us into confusion? Today, many Africans work in Africa as if they are in exile. They clean our streets, build our cities, raise our children, yet remain invisible under our flags. We have already inherited borders that are divided us. Let us not continue building on this legacy of division with borders that protect inefficiency and punish ambition. That is not sovereignty, that is fear disguised as policy. If we cannot guarantee dignity to African workers in Africa, what integration are we really talking about? This law is clear: protect the worker, regulate recruitment, recognize skills, and make decisions based on data, not politics. And that's how serious nations operate. President, we like to say Africa is rising. Fine, but rising to where? Rising without discipline is just drifting upward until gravity reminds you who you are. The model law gives us a test to prove we can govern complexity, to make migration productive, to turn remittances into investment and mobility into knowledge exchange amongst Africans, the same way we do in this Pan-African Parliament. We should not wait for anyone to tell us to protect our own citizens. Leadership is not about wanting for instruction or for someone to come save us. It's about anticipating responsibility. So let us adopt this law and implement it, not for applause, but for results. President, our people are not asking for speeches. They're asking for frameworks that work. And if we fail to give them that, then the problem is not migration, it is leadership. Thank you, Honorable President.
Muito obrigada.
Thank you, Honorable. Thank you for cooperating with us and keeping the time. I'll give the floor to Honorable Yokad Saba from Burundi.
Não está na sala? Então. Peço respeito.
Apologies, Honorable.
Madame la Présidente.
Thank you very much, Honorable President, for giving me the floor. I also like to speak about the issue that's of a concern to us. As we are all aware, there are so many migrants seeking a decent work in Africa. However, most migrant workers are doing so illegally, and consequently, these migrants are maltreated, expelled, or sometimes they lose their lives. Such a model law that seeks to improve the regulation of migration and labor is timely, as it seeks to protect these migrants and their rights. In our African countries, we are observing we are witnessing increase of our or proliferation of our population, but without the consequent measures for employment for young people and other segments of the population. And this leads to increasing poverty in families. And accordingly, and for the economic development of the country is concerned, Honorable President, let us hope that the adoption of this model law, that it will, and its implementation will help our respective countries and improve bilateral and multilateral agreements signed on migration and labor, and effectively control illegal migration in our countries. Thank you very much.
I will give the floor to Honorable Toure from Gambia.
Thank you very much, Madam President. Madam President, I want to adopt what my colleagues have said before me. I think they are very positive things. My intervention will be towards Article 11 and Article 8. And I will want Dr. Marius to help us here. First of all, I want to say whether this document explicitly explains anywhere that migration is not a crime. Those who are involved in the trafficking, we should not confuse traffickers with those who are migrating. I think we need to clearly explain that in the document that people have a right to travel and to move to other places to seek for greener pasture. Once that is clear, Honorable Speaker, I want to say that this law is novel and it is unique in its own right and is giving us the right direction. My question also is that migrant worker, the idea is for the worker, the employer, to take due diligence to help the migrant to be regularized. I have the feeling that that is going to expose, that is a good thing, but it will expose the migrant if the migrant fails to meet the criteria. So I believe that there should be a clear regulation that will stipulate, that will give some guarantees that the migrant, even though fails the criteria, will still not be deported back to his or her country. I think we need to clarify that. The other thing I want to say is that the article continues to talk about competent state organ. I'm not a legal-minded person. Competent state organ. Are we envisaging that there will be other organs that will pretend to be state organs and they will not perform like the state organ? Or are we saying that any state organ, as long as it is a state organ, It is a competent state organ. We need to clarify that at least to some of us who are not very legal. Thank you for the time.
Thank you, Honorable MP, and I hope that the consultants took note, because this is a question regarding Article 8 and 11. I will now give the floor to Honorable Margaret Kama from Kenya. You have the floor.
Thank you, Madam President, for the opportunity to join my colleagues. First, to congratulate the Committee of Trade for this very good model law, and to also thank the presenters and the consultant for the work they have done over a number of months. It's been a while. I was a member of that committee, and I really know the amount of work that the chair, John Bideri, and the team have put in this. And I congratulate them for that. As we look at labor migration, Madam President, it's impossible for us to talk about free movement of persons and after the African Free Trade Area without talking about mobility of labor itself. So it is so important that we have this law at this time, and I think it's a law really whose time is a must. So we are hoping, as the chair of the committee told us, that we go to our countries and encourage the countries to actually use the model law to develop laws for themselves, so that we allow free movement of labor in the continent. This is very important. As we said, the law is really focusing, as the President has said, on the dignity and fairness for laborers. Because if we continue to address a laborer from the neighborhood as a foreigner, it becomes very difficult for the development of the region. We know of instances of xenophobia, and we need to start addressing, because those are issues that must be addressed politically. Why do we have xenophobia? It's because of fear of job loss. And so we need to address the issue of job loss itself. Why are people not able to work within their country to the extent that they don't need too many immigrants? It goes back to what I would encourage our education committee to address: the training itself, the skilling within the countries. And we have Article 22, which is addressing skills enhancement and skills recognition in this model law. And even as it addresses state to look at its own skills and the skills they're producing for the countries of destination, we must encourage all of us to really look at the equality of skills recognition across the border. Are we able to do that? Again, I encourage another model law from the Education Committee that should be looking at equating of skills, so that we can Thank you. If we can allow another model law that will allow skilling and free movement of skilling, and always skilling, if you have to go and have your skills in the neighbors, we need to have consideration. I know in the East African community, we say that any skill or any university training should treat a student as a local student. Those are some of the things we need to look at. Social security is one of them in Article 27, which I think the presentation should still relook at. This person called the person in the irregular situation. I know I had questions when I was in the committee, and still ask myself, when you talk of social security, how much, what are we talking about? What exactly are we giving? Because social security in Kenya is money given to the elderly and to the employed and to PWDs. How do we do that to make sure that we protect even maybe we know that something like PWDs, you can create one even out of injury, and you have somebody injured and somebody losing employment. Maybe we need to come out clearly, but otherwise I would like to encourage members who received the document today to read it, because it's a very nice document and it may be good for us to read, and even as we think of having our countries use the model law to come up with their own laws, we must read this because it has a lot of very rich information. I thank the team. Thank you.
Thank you, Honorable. I'll now give the floor to the last speaker before giving the floor to the chair of this committee, Honorable Alimbo from Gambia.
Thank you very much, Honorable President. And thank you very much, Honorable Senator Bideri and the experts for this wonderful piece of potential legislation. Honorable Speaker, if we really want to see the integration of Africa, I think this is a good place to start. And I think being allowed to be able to move from one country to another and not being called a foreigner, and where you have the right to settle, to work, and also to raise a family is actually key. And I think this model law is a step in the right direction. Honorable Speaker, I just need to remind our own colleagues here that there is a protocol called the Protocol for the Treaty establishing the African Economic Community relating to free movement of persons, a right to residence, and right to establishment. This was done years ago, and until the last time I checked, only 32 countries actually have signed, but yet still we have only 4 that actually have ratified. Now, if we are really serious about African integration, and I think these are the issues of protocols or treaties that we really need to sign, because it's there already at the African Union. And I think this model law actually can help to supplement this free movement of people. But yet still we have it, 32 actually have signed, but only 4 actually have ratified since 2018. And included in those ones are Mali, Niger, Rwanda, and Sao Tome that actually have signed and also have ratified and deposited this instrument. And I think we really need to do better. On our side, I agree with Honorable Danson from Kenya. About ECOWAS, I think we've moved very far in terms of the free movement of people, in terms of the right to be able to settle in a member state from Gambia to Nigeria or to Ghana or to Senegal or to Mali. We really have gone very far, even though we do have challenges, but I think this model law is going to help us. Now, the question I have for the presenters is the issue on Article 9 and Article 10, and I want to be guided accordingly. Now, on Article 10, it's saying, migrant workers in a regular situation shall enjoy the right to participate in public affairs, to freedom of movement, to full access to social and health services. Now, in some countries, like including my own country, we have the National Health Insurance Scheme, where actually people contribute. Now, we would like to know whether that should not also be an obligation on the migrant workers. Because if you want to access the healthcare facilities of our own countries, where citizens actually are contributing, I think it's going to be effectively fair for those migrant workers also to contribute equally. Now, I've highlighted the same issue on Article 9, where you are also indicating that they are required to contribute to social security and taxation. I'm not too sure if that's going to cover, so I would like to be guided in that particular area. Thank you very much for this wonderful work.
Muito obrigado, Sr. Deputado.
Thank you very much, Honorable, for the questions pertaining to Article 9 and 10, and the comments were duly noted. I'll give now the floor to the chair of the committee to provide his concluding observations before giving the floor to the consultants to respond to the questions in full. Honorable Chair, you have the floor.
Pode vir aqui no púlpito, tendo em conta.
If you don't mind, you may come to the podium. Mindful that is an important law, and concluding observations should also have the same importance. Kindly come forward to provide your concluding observations, Honorable Chair.
Thank you, Your Excellency, for giving me another opportunity to talk about this model law, which is very important law, as highlighted by my colleagues. I'll not go into the specificities of the articles because my Professor Marius Olivier will be able to provide some clarification on them. But I would like on the onset to say that new substantive proposals being made are taken note of, and we will make sure that they are integrated into the model law, which will stand, of course, adopted with those proposals. I want to say that I want to appreciate the comments that have been made on specific articles, but also on the law generally, to say that this law is timely because, as you know, the Africa Continental Free Trade Area, which is already in place, really provides an opportunity for labor mobility on the continent, but also ensuring that the countries, the states in our continent benefit from economic opportunities that may arise. I also want to say that this law, other than being timely, it is also futuristic. It has incorporated almost all the articles that are provided for under the UN Charter on Labor, and therefore we have literally made sure that every aspect of human rights, equal rights, are taken care of in this particular law. I would also want to say that this law provides dignity to the citizens of this continent. Whether an illegal migrant, a migrant in an irregular situation, or a migrant in a regular situation, all those have been taken care of in this particular law. And therefore, I want to say that this law is a very important law, and I would urge honorable members to support it, to make sure that the citizens of these continents that we represent benefit from the opportunities provided in this particular law. I also want to say that this law actually provides a lot of opportunities for the citizens of this continent, particularly the youth. As you know, the youth forms a large proportion of our population, and we are also aware that the youth are highly skilled, and therefore this law will make sure that the youth on this continent really benefit from the opportunities that we have on our continent. The other one I would like to say is that this law ensures that the skills across the continent will be shared through the mobility. Thank you, Your Excellency, for giving me extra time. Yeah, so the skills will be shared across the continent, but it's also important to say that we need to put our skills recognition in place. And I want to really thank Honorable Margaret Kamal for suggesting that perhaps a model law that looks at skills equivalence may also be proposed from the Pan-African Parliament, because that will also ensure that when I move from country A to country B and I have certain qualifications, they should be equated immediately within the country of destination without delay, so that I can be able to either create a job opportunity or be able to access a job that is equal to my qualifications. Finally, I want to really take this opportunity to thank you, honorable members, for your comments. They were very moving, very positive, and I hope that when you go back to your countries, you'll be able to popularize this law so that it is either demonstrated in full where it is necessary, or parts of it can also be taken into consideration. I would also wish to thank the government of Kenya and the Parliament of Kenya that really hosted us during the consultative process, and the participation of the members of Parliament from that country in terms of providing technical inputs, but also facilitating all the delegates that had traveled for that consultative meeting. I would also wish to thank the government of Ghana and the Parliament of Ghana for having hosted us while we were working on the technical formulation of this model law. And I would wish to thank everyone, particularly the leadership of the Pan-African Parliament, that have supported us all the way until today. I wish to submit. Thank you.
Thank you very much. I would like to ask for another round of applause to this committee, for the chair, for the effort and dedication. Before giving the floor to the consultants to respond to the questions raised regarding to Article 9 and 10, 11, as well as 17, I would like to, regarding the question raised by Honorable Kamal on social security, to give a concrete example of my country. We have social security, which includes the provision in which the person receives for medical assistance, and also the deductions for retirement, medical assistance, as well as social pension, which is an additional component not linked to social security. So social security is within what we call social arrangement that the elderly receive. Those that did not contribute to social security, the state assures a survival pension, which is a social pension. We have in Cabo Verde, and also Cabo Verde offers social pension to its migrants. So people that migrated from Cabo Verde to other African countries who currently don't have social pension in these countries of residence. Cabo Verde also accords this social pension for Cabo Verde residents in other African countries. Just to make this distinction and give this example, I believe that consultants will bring this dimension for us to be clear regarding the concepts, because this model law will be domesticated in our national legislation. So the concept should be clear so that the legislation of this law don't bring confusion at the moment of being integrated in our own legislation. Having said that, I give the floor to our distinguished consultants, 3 minutes each to give clarifications on the articles, and we move on to the adoption of the draft model law that will be transmitted to the member states and parliaments, including the African Union. You have the floor.
Thank you, Madam Chair. Ladies and gentlemen, colleagues, I'm not going to comment on all the comments made, of course, because many of the comments were really in the nature of comments rather than recommendations. So let me then highlight the following. I want to return to the first Kenyan speaker who addressed a few issues. The one is on job applicants and that we should actually open up kind of the labor market for job applicants from African countries generally, if I understood his comment correctly. Now, let me say the following, that there is an in-principle distinction in international law and at the level of national law, an in-principle distinction between applicants for a job coming from even outside the country and those that have already been allowed into the country. There is no normative framework in international law, UN conventions, ILO conventions, for example, and even at the AU level, subject to the issue of agreements, which I'll say something about, there is no provision in international law that would force any country to open up its borders to any job applicant from outside. It does not exist. And I must say, if you look at the national level in terms of national laws in Africa, we have really perused the issue that there is simply no such allowance, generally speaking, for national laws to allow anybody to come and work, subject, of course, to the issue of free movement agreements, etc. So that is a principle. In fact, lately, quite a few of our countries on the continent South Africa being one, actually, have been introducing more stringent requirements in terms of allowing people to enter the country to come and work. So what countries generally do, I've seen it in Ghana and other countries, they close certain sectors of employment, of the labor market, for example, to foreigners, and or other countries may impose quota systems of how many may be allowed into the country in a particular occupational area, etc. So, but what is the exception? What is the qualification? Of course, agreements. It could be bilateral agreements, bilateral labor agreements that would allow people to move, and generally that allowance is always then circumscribed or limited. Free movement agreements are actually the more important arrangement, because you do have free movement agreements. If you look at the African Free Movement Protocol and the one in ECOWAS, and a reference made to some of the EAC instruments, what you have there is an incremental building up of allowing people to move within the region. And in the African Union, one would actually talk the same language for the continent as a whole. First allowing for visa-free travel, then as a second stage, allowance for residents to be taken up, and then at the third stage, the allowance to work. And then finally, the allowance to start your own business and so that kind of incremental approach is for, and that is of course what we need and want to support. But we cannot force this in a model law of this nature. We can say yes, we promote freedom of freedom of movement, which indeed we do in that article on facilitation of labor movement. And then the colleague also referred to the example of contribution to social health authority in Kenya, saying this is contributory. I wasn't sure whether that meant that migrant workers coming to Kenya would automatically be entitled to contribute, or they have to go through a special process. But I think the principle that we have outlined in the model law, which is an international law principle as well, is that in terms of contributory modes of social security, and include health there as well, that there should not be any discrimination between a national and a migrant worker who is in a regular situation, otherwise a so-called documented migrant worker. That is a principle and should always be followed. Now, if you put practical impediments, making very difficult for these migrant workers to actually enroll, then that could probably be seen, I'm not saying it is, but as a possible form of discrimination in practice, which has to be dealt with separately. Now, it's different with arrangements in social protection and even in medical assistance, if I could use the word, when it comes to non-contributory arrangement. Okay. There, what the international law and tells us, it's clear, it's up to every country to decide how far it goes, but it has certain minimum requirements that have to be met, in particular with reference to emergency medical care. Right, and then finally, there was the issue on the right to work. ECOWAS Free Movement Protocol was commended. Of course, that's true. And I think what I've already said covers the issue of the incremental approach in Free Movement Protocol. But the right to work generally is not recognized. It's different if you have allowed a migrant worker to come and work in your country, even if you haven't given that person permanent resident status already. And what the model law says, based on the ILO conventions, that once you have worked for a period of 2 years, then you can change employment freely. Okay, but that's how far the model law goes, and we cannot go beyond that, I would think. Again, the importance of free movement arrangements and importantly, mutual recognition agreements. Okay, then I think from our colleague from Chad, we have a question about percentage of migrant laborers leaving Africa. Do we have a sense of that? Nobody would be able to tell you exactly. In fact, the general sense in the literature is that the majority of Africans who leave, in particular the continent, to work outside the borders of the continent, are actually working on an irregular basis, and we don't have those figures. And that's one reason why we have to have this law, to try and to have an arrangement where we can try and regularize their position through bilateral agreements And I really think that is what the draft law tries to do as far as that is concerned. Brain drain, can we turn this around? The problem is employment, lack of employment in the continent. Our people move, our young people move because they need to work, and for the moment our countries cannot do so. But the important thing, and this is being recognized in the draft law in many instances, the important thing here is that there are different arrangements that can be put in place to support not just the return of these migrants, but the return of them being skilled. So the participation even of countries of destination in skilling these migrant workers abroad, even with a view to their return, is specifically acknowledged, I think it's in Article 23. So we have all kind of interesting arrangements arising, like skills mobility partnerships, etc. And this is a language we need to talk is to. We have to manage the flows of labor migration. We can't stop that. So we have to try and regularize this and make sure it happens according to what is in the draft law. And we have to make sure that we skill our people who move to work outside so that they can come back and work and contribute to that. And now you have a lot of supporting mechanisms. If you have portability of Social Security, for example, that's one way in which you ensure that those migrant workers who on a regular basis, as a regular migrant worker in a regular situation, went out to work in, let's say, a European country or another African country, and they contributed to Social Security there while they worked, that if you have a portability arrangement that they can or actually should bring back their contributions to Social Security or the benefits should be exported to the country of origin when they come back. All of these are supportive mechanisms to strengthen, again, the brain gain, that you gain from the brains that were kind of invested for some time overseas or in another African country and they come back. Okay, so as far as that is concerned, then I think there was a question, the Article 8, Article 11, there were three issues mentioned by one of our Gambian colleagues. Migration, not a crime, is that not mentioned in the model law? Well, conversely, what is mentioned very clearly in the draft model law is that human rights of those who move, in principle, are intact. We cannot touch that. And that is a clear understanding that migration, even labor migration, is not a crime, not at all, I would think. What about people who haven't met the criteria we were asked of being regularized? Surely they should not be deported, if I understood the colleague correctly. I'm afraid the problem is why we focus so much on trying to have people's position regularized is to avoid deportation. But the immigration laws of countries concerned all over the world are such that if you are in an irregular situation and you haven't managed to have your position regularized through a work permit that has been now approved, etc., then you will, in all probability, be deported. And that is clearly the national rule even in most African countries, and I don't think through the model law we can try and change that, and perhaps we should not even try to change that. There was a question also by the same colleague about the reference to competent state organ, authority or institution. The legal counsel of the Pan-African Parliament, who I saw here a few moments ago, he actually inserted all of those provisions rather than to say that every state should, in order to align this model law with the other model laws. Now, the reason, of course, is that if you refer to a competent state organ, authority or institution, you do not pinpoint who exactly is the state organ. It could be a ministry, it could be a special institution or council being set up, and the same applies to authority. That's the essence of the answer for that one. We have a question from our last speaker from Kenya on the Social Security for irregular migrant workers. I think we try to highlight that as already outlined in Article 22, that irregular migrant workers, or rather migrant workers in an irregular situation, would not have an entitlement even to contribute just freely to the social security system of the country concerned. But very clearly that article, and it's also replicated in another article in the I think on the regular migrant workers, in fact, article, what was it, 10, 11 rather, is that if you have contributed to social security, even as a migrant worker in an irregular situation, you are entitled to draw down at least that what you have contributed to. That is a basic principle enshrined in the ILO conventions and in the UN convention as well on migrant workers and their families. What about migrant workers in irregular situation and non-contributing social security benefits? As I said earlier in my basic presentation, is that the rule there is that no, they're not entitled to non-contributory social security, except that, and that applies to all migrant workers, that at least there's a minimum level of assistance or subsistence, if you like, that would have to be guaranteed based on the national social protection floors that may have been established by the country concerned. And that is the ILO guidance as well. Finally, our final colleague from Gambia on documented migrant workers, Article 10, equal contributions. Well, that is exactly what we are saying, is that if you are a migrant worker in a documented migrant worker, in other words, a migrant worker in a regular situation, then you should be entitled to contribute on an equal basis to any kind of insurance-based or contributory-based arrangement. I hope I've answered that question, and I hope I've addressed the specific issues that are relevant, Chair. I thank you, colleagues, and Chair. Thank you.
Muito obrigada.
Thank you very much, Professor Oliver. I give the floor now to Mr. Alexio Musundu for concluding observations.
Thank you very much, Chair. And also, in the interest of time, I think Professor has answered most of the questions. Just to add a few, what I might say, parting shots. I think from the ILO, to get labor migration to work effectively, one of the issues that is the importance to create jobs at home, so that migration does not become a necessity, but then it becomes a choice, and in that way, the market needs of the destination country would also make it easier, because there will be supply-demand that comes in. So creating employment opportunities for the young people is one. Second, related to the issue of the brain drain, then comes not just about the quantity of the jobs, but the quality of the jobs. One of the causes of the brain drain is around young people looking for places where they can work, where the quality working conditions are much better. So I think as we discuss, as we implement the model law, the importance of creating employment opportunities becomes important. Just to reemphasize also what Professor mentioned, that the ILO does take into account that there's no obligation for countries to open up all the jobs. Countries can reserve some professional positions, in particular in the public service, for their national. The question that was also raised on statistics, again related to the brain drain on the number of Africans working outside the continent or even within the continent, but in other countries. Over the last 7+ years, through the joint labor migration project that the ILO has with the Africa Union, we have been working on trying to improve labor market information data on labor migration. And you'll find that in the last 7 years, a number of countries when carrying out their integrated labor force survey, there is now a module on labor migration. And I think the more countries include that module on labor migration, the more information we'll be able to get on migrants outside. I think we have some very good data on remittances, but that has to be merged also with that. The other issues, I would say, they have been addressed and won't be a need to repeat them. So let me just conclude, Chairperson, by also thanking the Pan-African Parliament and, of course, the committee chair and the members of the committee for giving us, as ILO, an opportunity to contribute to this important law that is going to affect thousands, millions of young people on the continent. I thank you.
Muito obrigada.
Thank you. Now I think that we are in condition to submit the report on model law on migration for approval. Before that, I'd like to do the final consideration. And with this, I'd say that with the approval of this model law, we are fulfilling what is our mandate within the Pan-African Parliament, which is the legislative board of the African Union. We are now ensuring the respect for the dignity of human dignity to our migrants, freeing them from the slavery work in some countries, member of the African Union, which is their own continent. So we are now creating conditions so that our migrants may have access to education, health, financing, social security, housing, and a worth employment. So we are giving dignity to our young generations, taking advantage of what we have as a wealth of our richness from our demographic continent. And this law will give opportunity, a dignified work to our youth of our continent, but also we are accelerating the implementation of the 2023 agenda. We are also accelerating the implementation of African Free Trade Zone. We are also contributing for the free movement of people and goods in our continent, but also contributing to an effective integration of African citizens within our continent. With this, I will now table the report to the plenary for its approval and adoption so that the President submit this paper to the member states or to the borders of the African Union, including the office of the legal officer, and also present in the next Head of State Summit in February 26 in Addis Ababa. With this, now I'm tabling the report for consideration and approval of the plenary. Thank you. So there is no any objections. So now we can consider as the report approved. And this, let's now applaud. A round of applause. With this, we consider the report approved. Now, let me now give the floor to the Deputy Clerk, Mr. Galdi, to announce on the next items. So now I will leave the bureau. My colleague is now to replace me, who will now preside over the next meeting. I thank you for your collaboration. I know that we went behind the time, but I think it was necessary to do this exercise in an open manner and accept the contributions of all MPs as well as of our consultants, and then we consider as our work concluded. Now I will hand over the first Deputy President to preside over the meetings. Thank you very much.
بسم الله الرحمن الرحيم. السلام عليكم أيها الجمع الكريم، الأخوة والأخوات، السادة النواب المحترمون. سنكمل جلسة اليوم.
Greet you to give us to have the secretary
concernant cette matinée. Merci.
The Deputy Clerk will now make announcements on the rest of the program. Thank you, Madam Vice President. We are now going to have the presentation and adoption of the model law on gender equality and equity in Africa. The model law will be presented by Honorable Khadija, who is the Vice Chairperson of the Committee on Gender, Family, Youth and People with Disability. Thank you very much, Mr. Deputy Clerk, and it's a great pleasure for me to invite our Honorable MP Khadija to present on the model law on gender equality and equity. Thank you.
بسم الله الرحمن الرحيم. السيدات والسادة النواب، السيدة الرئيسة، السادة أعضاء مجلس.
Thank you, Madam Vice President. Thank you, Honourable MPs. I would like to thank you all for this opportunity. On behalf of the whole Committee on Gender, Family, Youth and People with Disability, I'd like to express our profound gratitude to our partners, including the Centre for Human Rights at the University of Pretoria, GIZ and Equality Now, for all of their contribution and advice with regards to the development of the model law on gender equality and equity in Africa. And it's a great honor for me to present it to you today. Our sincere thanks also go to the regional parliaments and the organs of the African Union, as well as organizations from civil society for their constructive contribution to this process. Honorable Vice President and dear colleagues, this model law is a collective work between various parties across the continent after the Protocol of Maputo, and taking into cognizance the challenges that Africa is faced with, including civil, political, economic, social, and cultural challenges. We take note of the persistent inequalities that exist between men and women on the African continent, and we hope that the model law will be a framework for the various African states to create an inclusive society for women and the girl child in Africa. And we hope that this model law will help to allow Africa to translate its promises into action and into reality. The model law contains 16 chapters and 75 articles that describe the rights and obligations with regards to gender equity and equality in Africa. And the model law begins with a preamble, and this preamble reaffirms the commitment of member states to uphold the principles of human dignity, equality, freedom, justice, and solidarity as enshrined in international, continental, and national legal instruments. It acknowledges the historical and structural inequalities that have contributed to the marginalization of women and girls, and recognizes the need for deliberate and sustained efforts to dismantle discriminatory systems. It also emphasizes the importance of gender equality not only as a human right, but also as a prerequisite for sustainable development, peace, and social cohesion. And it promotes the equality of opportunities, equality in terms of remuneration, eliminating violence and harassment in the workplace. It also aims to reduce and eliminate harmful practices such as early marriage and female genital mutilation. We have also taken into consideration the fact that gender equality needs to be taken into consideration in conflict situations and also in terms of people living with a disability. We need to also provide for women during pregnancy, and we need to ensure that women are able to have their pregnancies and give birth in a correct, sanitary and safe environment. I would like to thank all the members of our committee for all their commitment and for their contribution to this model law. We believe that change is possible, but it will require the political will and commitment of African leaders. And this model law will be able to change our policies and programs to lead to greater social justice in our countries and create the Africa that we want for tomorrow, an Africa that is for gender equality and equity. And I am now submitting this model law for your consideration.
Qui sera gravé dans le registre de notre peuple, parce que pour écrire une nouvelle page dans le chapitre de la légalité et de la dignité. Oui, c'est ça. Oh.
ليعيد للمرأة الإفريقية كرامتها وصوتها ومكانتها التي سرقت منها.
Can you hear the interpretation? Can you hear the interpretation?
نريد تأكيد حضور
Can you hear the interpretation? English? To French? From Arabic to French?
Arabic to French, yes.
ترجمة من العربية للفرنسية. من فضلكم.
C'est bon?
سيد الأمين عبد، c'est bon?
Yes, please go ahead. Thank you, Madam Vice President. I was saying that we are at an important crossroads, a historic moment for Africa, and we are turning an important page here with this model law on gender equality and equity. This model law is the first of its type in Africa, and it will guarantee the dignity, safety, and equality of women across the continent. And we hope that all African countries will seize this opportunity, because imagine you have a child in a far-flung village in Mali or in South Africa or elsewhere in Africa. This young child has its dreams, has its needs, and this child needs to be protected through laws. This child has rights. And whether this child is a boy child or a girl child, those rights should be the same. This law is not just a law that should be approved and adopted by the Pan-African Parliament. It needs to be adopted by national parliaments because it represents hope for the future for women and the girl child. It is a model law that is written for all African states, for all political parties. It represents the voice of the African people who want to liberate women, liberate the girl child. And we need to use our voices to turn this into reality in our various countries. And I am therefore asking you to domesticate this model law, ensure that it is integrated into your national legislation so that women and girls can benefit from the same rights as men and boys in your country. Africa needs all of its children, boys and girls, and to build the Africa that we want, this model law is a key step. I would like to finish off by once again thanking everyone who was involved in drafting this model law, including the members of the committee and our partners. And I would now like to hand the floor to our legal counsel, Mr. Clement. I hope he's in the room, because Mr. Clement has worked very hard with us in developing this model law and in helping us to ensure that this model law respects all the legal norms across the continent. I would therefore like to ask Mr. Clement to please take the floor with your permission, Madam Vice President. I would also like to thank Madame Rubin, who also was heavily involved in drafting this model law on gender equality and equity. So without further ado, please can we ask Mr. Clement to give us a brief comment and summary on this model law. And I would also like to ask the honourable MPs to give us their opinions and contributions on this model law so that we can adopt it and present it to the various organs of the African Union. And the model law will then become an official document that countries can use. Thank you. Thank you very much, Madam Vice Chair of the Committee on Gender, Family, Youth and People with Disability. You have given us some very important information on the model law on gender equality and equity. And as you said, we need to work to achieve the dignity of African women, and we cannot achieve development in Africa without fighting for the rights of women and the girl child. I would therefore like to give the floor to the legal counsel, Mr. Clement, to be able to speak to this model law and its drafting. Thank you.
Okay.
I believe that we are missing the text in Arabic. The model law does not seem to be available in Arabic. Mr. Gali, can you please tell us where the text is in Arabic? We do not have a translation of the model law in Arabic. All members of parliament need to be given a copy. Even if it's an electronic version, it's very important that the Arabic speakers have a copy.
Le texte a été distribué depuis hier.
Madam Vice President, we have distributed the model law text to all MPs electronically, so they definitely should have an electronic copy in Arabic. I will check outside to find out if the Arabic printed version is available. Thank you. Thank you very much, Mr. Deputy Clerk. It's very urgent, so we are counting on you to sort this out. Thank you. Mr. Clement, you have the floor.
Merci beaucoup.
Thank you very much, Honorable Vice President. Thank you for giving me the floor. Honorable members of Parliament.
Try and briefly present to you the content of the model law on gender equality and equity. And with this assignment,
Excusez-moi, Monsieur Clément, on n'a pas la traduction en français ou en arabe. Je ne sais pas les traducteurs quel est leur problème, mais il y a toujours un retard de traduction des interventions. Vous êtes prêts, la traduction en français? Mais il a continué en anglais, c'est son droit. L'essentiel, est-ce que vous êtes prêts maintenant? D'accord, on continue. Continuez, Monsieur Clément.
Thank you. I was saying that I will basically cover 4 issues. An overview of the mandate. I will take you through the guiding legal and policy framework on which basis the model law was developed, and the stages of its development, and then I will delve into the substantive elements of the model law itself. Briefly, the mandate for developing this model law comes from the Constitutive Act of the African Union and the PAP Protocol, as well as the rules of procedure. No need to repeat, but most importantly, 2 resolutions of this parliament. The first one mandating the Committee on Gender to develop the model law, and the second one, when the model law was developed and came for the first reading, the committee was further mandated to conduct consultations, thanks to which the model law was further updated with inputs from the various stakeholders, including civil society, national parliaments, and so forth. Let me move to the guiding legal and policy framework and say that the model law is seen as an instrument aimed at facilitating the domestication of not only African Union treaties and policy instruments, but also international instruments and even the instruments existing at the sub-regional level. That's why inspiration was drawn primarily from the Maputo Protocol, but also a wide range of instruments, human rights instruments at the African level, the policy instruments, but the CEDAW, the Convention on Elimination of all forms of discrimination against women. It's a UN convention, the ILO conventions, and a wide range of instruments adopted at the ECOWAS level, the SADC, the East African Community, and so forth. An effort was also made to ensure that some good existing laws that we already have at the level of the member states could be harnessed to ensure that the model law incorporates best existing practices. Also, in developing the model law, we took cognizance of the fact that in ratifying international treaties, particularly the Maputo Protocol, some member states have made some reservations in relation to specific articles of the Maputo Protocol, for instance. You will see, for instance, Kenya having made a reservation in relation to military spending, the rights of reproduction, Namibia, reservations in relation to the recording and registration of customary marriages, and so forth. We tried to understand the rationale for some of these countries who have made those reservations to ensure that the model law can be made as flexible as possible so that when these countries are made to adapt the model law in the national circumstance, they can have the necessary leeway to do so. In some instances, some other countries did not make reservations, but they made what we call interpretative declarations. It's also almost similar to reservations because here these countries are trying to give their own meaning to a specific article. So those reservations and interpretative declarations were taken into account, but we also took into account existing and evolving realities on the ground. Today, for instance, we talk about artificial intelligence, climate change, and other developments. The model law tried to be made to accommodate or to regulate these developments. The process of its formulation basically involved so many stages, but in a nutshell, I would say the process was participatory and highly consultative with a wide range of civil society organizations, African Union institutions, UN institutions, and other stakeholders being involved in the process of consultations which took place in Southern Africa, in Central Africa, Eastern Africa, and Western Africa. But in these consultations, participants from the Northern Africa were also part and parcel of the deliberations. Let me now move to the substantive element of the model law, which has 75 articles. Probably given the time, I may not be able to go deeper into each and every article, but the August House will note that the model law is embedded. The preliminary part of the model law, maybe one of the highlights is the guiding principles. The guiding principles are basically what gives policy direction and meaning to the contents of the various articles that we have. And we also tried to include definitions to ensure that the various concepts used in the model law would have no ambiguity, even when they are used or adapted by the member states. Part 2 relates to equality and non-discrimination. And this comes from the fact that a model law on gender equality and equity comes from the fact that equality and non-discrimination is and must be reaffirmed. And this is what basically gives inspiration to many other provisions, because the basis is that men and women are and shall be equal, and no one should be discriminated against. And one other aspect of this part is reaffirming the right to human dignity, regardless of the gender, the right to life, and particularly ensuring that the member states put into place concrete measures to address and eliminate practices which may hinder equality and dignity and the right to life. Part 3 relates to equal protection and access before the law. And the highlight here is that while the model law proposes that women and men should have equal access to justice, some specific measures are proposed to ensure that the justice system is equally accessible and can protect both men and women equally. All barriers to access to justice should be eliminated, and particularly, and in relation to the previous model law, equal access to equal protection to the law also means that the rights of migrants should be factored in, regardless of their gender. And lastly, there's a vulnerable group within the justice system, detainees, who also normally face discrimination, gender discrimination, provisions in protection of men and women in the context of detention are included in the model law. Part 4 relates to political participation, and generally the model law reaffirms equality and equity in the political sphere, and particularly requiring the competent state organs to put into place mechanisms to empower women to compete equally with men, and where possible to institute quota measures for women and the youth. Provisions are also in place to ensure that political parties also have some obligations to facilitate gender equality and equity for women, but also for young people, and to strengthen selection mechanisms for any candidates that may have to compete. Lastly, maybe one highlight is also some provisions to curtail abuses in the political sphere. Part 5 relates to measures aimed at advancing equal opportunities. We have provisions facilitating and promoting equality and equity in relation to access to land, access to education, and in relation to access to education, a specific focus was made on sexual harassment in schools, but also equal access to education for adults. Part 6 relates to equal access to economic and social opportunities. Provisions relate to facilitating equal and equitable access to entrepreneurial opportunities, equal protection of men and women in the informal economy, equal and equitable access to procurement opportunities, financial resources, access to adequate housing, and particularly for women, but also persons with disabilities. And Part 7 relates to labor and employment. In a nutshell, provisions buttress on equal remuneration, protection from violence and harassment in the world of work, and elimination of gender-based violence, and protection. So basically, promotion of equal treatment in employment and occupation, and elimination of all barriers to access of all persons, whether men or women, in leadership positions. Part 8 relates to combating gender-based violence, exploitation, and harmful practices. And this part contains a wide range of provisions aimed at eliminating a wide range of harmful practices. And these practices are basically listed. They range from FGM to scarification, breast ironing, medicalization of female genital mutilation, and other harmful traditional practices, including forced marriage or early child marriage.
Monsieur Clément, je vous rappelle qu'on a une autre.
Mr. Clipman, we have another report to present, and followed by debate. So if you can summarize, that would be a good thing. Thank you, Honorable President.
Maybe the remaining parts of the model law relates to obstetric violence, equality and equity in marriage and family, and gender equality and equity in conflict and post-conflict situations. And then the model law tries to also cover specific issues pertaining to vulnerable persons and minority and marginalized groups, such as the older persons, persons with disabilities, and frontline childcare and protection workers. The law could not limit itself to just asserting or elaborating provisions. A mechanism for its implementation and monitoring is also embedded in the law itself. And then we have miscellaneous provisions, which are basically standard for PAP model laws. So basically, in a nutshell, the model law on gender equality and equity proceeds from the fact that only basically assumes that gender equality and equity provisions or policies anchored in legislations are better placed to protect. Secondly, the model law addresses in one set of an instrument elements that are probably covered by one or several laws, but it constitutes a complete toolbox. Since I have to conclude, let me conclude with this quote by Graça Machel, who opined that gender equality and equity is the goal that will create more equal economies, fairer societies, and happier men, women, and children. With this, I thank you for your kind attention. Merci beaucoup.
Merci, Monsieur Clément, pour
Thank you, Mr. Clement, for that complimentary information you've provided. Now I'd like to open the floor for a debate on this report. The first speaker is Honorable Foko from Lesotho.
Honorable Foko.
Honorable Foko, you have the floor, please.
Excellency, I would like to express my sincere appreciation and gratitude to all who worked diligently on the development of this crucial module on the law on gender equality and equity. This is one of the most important laws, and going through this, though we have so little time, I realized that almost everything is covered. And this shows that the Pan-African Committee and all those who worked on this are aware of all the challenges that Africa is going through. It beats my heart to find that we have even now understood that gender means both or all who are involved around us. That is boys, girls, and people with disability. And also that when we look at section 22, we are talking about the equitable access to education. It is very important that each and every child is able to go to school. And they have even realized that some are not able due to the culture of our continent. Some are very far from the cities, and that is very, very tedious for them to get to schools. And also that we are having a problem or a challenge at school facilities, so that those people who are having disabilities will be able to access the school premises or even understand what is happening around them when they are in classes. Remember, we have people who cannot see, those who cannot hear, those who cannot even talk. So they must be catered for, and that is really good. We also have the sexual harassment in schools. That is growing, and seriously, there's been laws preventing that for a very long time. What we are supposed to do as nations or as Africans is to find out why it is continuing with so much freedom. Is it because of all of us having equal rights? And so the abused and the abusers all have equal rights. Is it because justice is denied and delayed? So we have to look at that, and we must really, as we get to our national parliaments, talk about that. This sexual harassment make it very impossible for children to go to school. It is now not only on girls, but even boys are being harassed by their teachers. Also, teachers are being harassed by students, both sexually and physically. We are having this GBV matter that we have been debating on for eternity. It is also very cumbersome. How are we going to get that to stoppage? That means we have to do education, a fairer education that starts from the grassroots upwards, because at times people just think that is how we are supposed to discipline each other. One other thing that has been there and we must do all we can is a challenge of women being abused. In some African countries, women are being abused by being forced into early marriages due to economic factors. Women are being abused by being, I don't even know how to say this, because every time I hear of that, it takes me back or to a position where I don't even know how people do such a cruel thing. It is done here in Africa, where girls are being, but fortunately it has been addressed in this good paper that such acts must come to a gentle stoppage. But we have been talking about that inside the parliament here. And the women over there have been talking about this genital mutilation matter and other harmful practices that happens to fellow women across Africa. So we really think it must come to a gentle stoppage. And we appreciate the fact that now we are saying, let's end it. Thank you very much.
Merci.
Thank you, Honorable. The floor now goes to Honorable Senator Mr. Honorable Mungatana.
Thank you for giving me the floor. Your Excellency, maybe the first thing is to congratulate the presentation that was there and request that legal counsel maybe can take notes on this final contribution from us so that you can infuse it in the final document, even as we adapt the documentation. Your Excellency, I just rose so that I can make one comment, and this is with regard to the part 4 of this model law, and this is on political participation. Your Excellency, we need to be stronger in terms of the framework, more mandatory in terms of the framework, so that this law can say clearly that in Africa, across Africa, the model law is saying 30% of the seats must go to either gender. 10% of the seats must go to the youth in all deliberative assemblies that are in Africa. This law must go out in that manner so that the countries that will receive this law, they will look into ways and means of making that sure that this happens. Why I say this is because there is no uniform framework in Africa. Your Excellency, what we have is a few countries that have reserved the seats for women, and then a few countries that they use parity laws and political party quotas to increase the number of women in the deliberative assemblies. But we don't have a unified approach. Your Excellency, what I have found out is that in Kenya, and in particular our Senate, where I serve, we were able to bring the numbers of our women senators to the mandatory 1/3 because of the Constitution of 2010. And it is very clear, in Kenya now, if we go for elections, we have 47 counties. And in each of those counties, we elect one senator. And if the women are also allowed to contest, but if the number is such that it is not 1/3 of each gender, then political parties are forced by law to nominate women senators so that we have specially elected women senators, so that at any one time, the Senate by law is 1/3 of either gender, and you cannot change that. So what am I saying? I'm saying these provisions, if we make them politically, constitutionally and legally binding, then we will have a jump in the number of women who are sitting in our assemblies. Your Excellency, I have gone through, and what I have seen, there are countries which have reserved, and they are clearly reserved. For example, Rwanda, 24 out of the 80, they must be women. Tanzania, out of the 393, there are 113 who are supposed to be especially reserved for women through political parties. In Uganda, they elect one woman for every district. In Kenya, I have said about the Senate, but in the National Assembly, you have one woman seat for every county. So you have 47 reserved seats. Somalia works out its quotas in such a way you have 30%. And now Zimbabwe has 60 for women and 10 for youth. Now these countries have clearly come out and say these seats are reserved. But then when you come to other countries that have huge numbers or have boosted their numbers, they have used party quotas and they have used parity laws. And congratulations to Senegal, Mozambique, South Africa, Benin, Mali, Ghana, and maybe other countries that I have not seen. These parity quotas and political party quotas, parity laws, and reserved seats, why can't this model law now take this opportunity to create a uniform framework for Africa? Why can't we say, let us do like what Somalia is doing, 30% women, and then for the youth, let's say 10%. And then the countries can work out their own mathematics to make sure that they abide by that provision. As I see it, Your Excellency, there's a problem when it comes to youth representation. And we have seen that Gen Z now, it's a real issue that we need to deal with across Africa. Many young people now want to participate in political leadership, in decision making. But the quotas, we have been talking so much about women, but we have left out the youth. That's why I'm saying we have an opportunity now as this Parliament of Africa to say, let us now start pushing 10% of all deliberative assemblies in the continent of Africa should have at least 10% youth as we create the 30% for women. Your Excellency, I thank you for the opportunity.
Merci, Honorable Senator.
Thank you, Honorable Senator. I think the topic is quite interesting, so much so that everybody wants to take the floor. And it is useful, as was suggested by the Honorable Vice President. So please, it will be advisable to submit your proposals to the committee so that we can incorporate them into the final version. Without further ado, I'd like to invite Honorable from Mozambique, His Excellency Damião Joseph, to take the floor.
Thank you very much, Madam First Vice President of Pan-African Parliament, to give me the floor and our honor that I have to participate in this debate with an issue that is very important and in the government of Mozambique, in my country, has defined as part of its strategic objectives, which are the promotion of equality and equity of gender in the several spheres of the economic, social, political, and cultural development. Madam Vice President, I think that I may not be wrong if I say that today is a very historical day for the Pan-African Parliament and also for Africa. And being in this August House deliberating about this model law on gender equality and equity in Africa, an issue that I believe to be very relevant and cross-cutting. I would like to say that as a man with a capital H and that of a member of Parliament of Africa, I do assume and reiterate my commitment to continue to promote unconditionally all the initiatives that aim to promote equality and equity in our countries, as well as in Africa in general. I am convinced and I'm faithful that this model law is pertinent, as is opportunistic and meritorious. It has merit, and its adoption and implementation by our countries, it would be a valuable contribution, an invaluable contribution to reduce inequalities amongst women, men, and could also contribute in the fight against poverty, above all, the empowerment, economic empowerment of women. To close, Madam First Vice President, I do confess that even as I've said here, that I am a man with a capital H, I do believe in the power and the leadership power of women to cure and save our nations, leading with compassion in several fronts, building stone by stone, and a more united Africa, a more inclusive Africa, a more just Africa, and Africa with only one voice. Here in the Pan-African Parliament, we do have some live examples of the leadership power of women. Because time is scarce, I'm going only to mention a few. Just one example. I'd like to refer to Madame Mariam Dawn Gabala, and I hope I have mentioned your name correctly, President of the Commission on Gender, Household, Youth, and People with Disabilities. This is a very live example of the powerful leadership of women. This committee that is only led by women, in my humble opinion, has been one of the most dynamic and proactive committees in PAP. Long live women in PAP. Thank you. To close, I'd like to take this chance to express my recognition and salute the Bureau for their work and efforts that they've been carrying out so that one day our rights can be restituted and respected by whom it may concern. For having listened to me, thank you very much.
Merci, l'honorable.
Thank you, Honorable MP. Now, the floor goes to Honorable MP of Zimbabwe, Madam Masuku.
Madam President, and thank you to our presenter, the Vice Chair of the Committee on Gender. Madam President, I'm happy because this modern law is not just for women, but girls, elder people, and people with disability. I rise today as a woman of Africa, standing on the shoulders of the women who carried this continent through struggle, nation building, and hope. Madam President, we debate the model law on gender equality and equity, yet this is more than legislation. It is a moral correction, a continuation of our liberation story. Africa has never lacked strong women. From Ya Asantewa and Mbuyane Handa to Winnie Mandela, among others. Our history is rich with female courage. But while we honor their memory, our systems have not always honored their rights. This model law offers a new promise by ensuring equal access to education, work and leadership, protection from gender-based violence, equal access to land and finance, removal of discriminatory laws, strong accountability in every member state. This is not charity, it is justice. It is not a favor, it is restoration. Madam President, too often our politics falls into pettiness, faction, ego, competition. But gender equality is bigger than all of us. No nation will rise while half of its population is held back. No economy can prosper while half its talent is ignored. No democracy is complete while half its citizens are excluded. Madam President, in Zimbabwe, we recognize milestones worth celebrating. Women now occupy important leadership positions in parliament, the judiciary, and government. Our constitution guarantees equality and outlaws discrimination. Critical laws protect women and girls from violence and early marriage. Madam President, women are in agriculture, driving food security. Women in business are reshaping local economies, and girls' education continues to improve. These gains show that when women rise, families rise, and nations rise. Madam President, let us not fear to do what is right. Let us rise above partnership and personality. Let us unite behind this law, because the liberation of Africa women is the liberation of Africa itself. I ask you, honorable members here present, let us adopt this model law with courage and humility. Let us prove that Pan-Africanism is not just a slogan, it is by action. I thank you, Madam.
Merci, Honorable.
Thank you, Honorable. I now give the floor to Honorable Welcome Dlamini from Eswatini.
Thank you, Honorable Vice President. Honorable President, I'd like to thank the committee that is responsible for this model law. It's quite an important model law, but I have some few reservations regarding the contents or lack of some content. Firstly, Madam President, I'd like to say that I'm concerned, or maybe may I seek clarity from the committee responsible as to why there is no definition of marriage in this model law. I say this, Honorable President and honorable members, because I am concerned that in Article 50, which provides for the registration of all types of marriages, then that presents a problem, Honorable Vice President, because when we're saying that registration of all types of marriages, we're then saying that we now we recognize same-sex marriages. Because in the first instance, there's no definition of marriage. What is marriage? It's not there in this law. And then we then provide for the registration of all types of marriages. In my country, we do not recognize same-sex marriages. But then this model law says that we should register all types of marriages. That presents a problem. Why has that not been clarified in terms of defining what a marriage should be? I'm happy that my honorable colleague from Zimbabwe, Honorable Masuku, just spoke of how important it is for us to push and to maintain the spirit of Pan-Africanism. And same-sex marriages definitely do not fall under that category of Pan-Africanism. And we should safeguard our continent through this model law by not providing for the registration of all types of marriages. I would prefer if we would say that, if I can read the Article 50, Honorable President, Article 51, which says that the competent state organs, institutions, and authorities, as well as other relevant stakeholders, shall carry out the registration of all types of marriages. Why don't we substitute the all types and just say the registration of marriages, which then we believe should be recognized by the respective countries? I don't want to impose my own suggestion on what the definition should be on marriage, because my definition would say a voluntary union between a man and a woman, recognized under either civil, customary, or religious law of that respective country or respective state. Moving on then, Honorable President, there is the issue of the definition of child marriage, which there also I would like to seek clarity from the committee, because the definition there says that a child marriage is means any legal, religious, or customary union involving a person under the age of 18 years, regardless of whether the marriage is formalized or informal. Not that I'm opposed to the definition here, but I want to seek clarity when they say any legal. They're including any legal. Then you want that part to be nullified, but you're saying it's legal. Why don't you then remove the legal and say any religious or customary union? I said any union, whether religious, customary, or otherwise, involving a person under the age of 18. That is my suggestion, because as it is, it creates a contradiction when you say it's illegal, but you want it to be not to be recognized. And then finally, this one is a warning on Article 45(1), which talks about education, which says that to ensure that information on health and sexual reproductive rights is available and that children are educated on same from an early age with age-appropriate information. I'm well aware that it's saying with age-appropriate information, but that is, we've seen that being done previously, where they include the age-appropriate information, but then when you get to the content of the material that is shared with our children in schools through what is called comprehensive sexuality education, which many African countries have signed into recognizing, you find that the content there is quite graphic, even though it's for children as low as grade 1, where you find them being taught about eroticism, how to sexually arouse a girl, and for the girl to how he can sexually arouse a boy. So we should be careful on this one. Maybe we should be specific. We see on the age, because when you say a child, appropriate age, then it's subject to being abused. Otherwise, I'm in full support of the legislation, proposed legislation, as long as we take care of the issue of marriage, just to protect our institution of marriage and institution of family. Thank you, Honorable President.
Merci, Honorable.
Thank you, Honorable MP. I think you should approach the committee to share with them your views, and they will probably give you the answers that you are seeking and the answers to the issues that you raised during your intervention. Now, I'm going to give the floor to Honorable Ibrahim Barakat from Djibouti. Thank you, Honorable Chair. This is a very important law, and we are in full support of it. In Djibouti, our sisters have high-ranking positions, but I think there are a number of measures that can be implemented to secure women's rights. The prohibition of female genital mutilation is one such measure in Djibouti, and a 6-month maternity leave for women in public administrations and other public institutions has also been implemented. And to date, women represent 20% of the MPs at the Parliament of Djibouti. It's not enough, but it's usually a matter of negotiations between the various parties in the country. And I think through awareness raising of the citizens in the country, we can increase that representation. Thank you. Thank you, Honorable MP. I would now give the floor to Honorable Estelle Mutola from Kenya.
Madam President, distinguished colleagues, allow me to begin by thanking all the presenters for their clear and thoughtful contributions. I also wish to sincerely commend the Committee on Gender, Family, Youth, and People with Disability for their dedication to this work of producing the model law on gender equality and equity in Africa. The model law provides a comprehensive and practical framework for promoting equality, protecting rights, and addressing the long-standing injustices that affect millions across our continent. At its core, it reaffirms one of the most fundamental principles, that men and women are equal before the law and shall not be discriminated against on any ground, including sex, gender, marital status, pregnancy, health status, or disability. This principle guides the entire structure of the law. Colleagues, I want to highlight the importance of reproductive health and bodily autonomy. The model law states that every person has a right to make free and informed decisions regarding reproduction, fertility, and family planning, and access to reproductive health services. It further requires that the state ensures access to affordable, quality reproductive health care, including prenatal care, safe delivery, postnatal care, infertility services, and emergency obstetric care. These provisions strengthened the dignity, well-being, and public health across Africa. The model law also addresses harmful practices that continue to affect women and girls. It expressly prohibits FGM, forced and early marriage, breast ironing, scarification, and medicalization of FGM. These protections are essential in safeguarding the rights and future of our children. Economic empowerment is another critical pillar. The law requires states to ensure that equal and equitable access to procurement opportunities, financial resources, land, property, and adequate housing are all catered for. And in this world of work, it guarantees equal remuneration for work of equal value, as well as workplaces that are free from violence, harassment, and discrimination. These measures support fair participation and economic independence. Honourable members, our responsibility now is to take this work forward. Model laws have impact only when they have been domesticated. I encourage us to bring this model law to our national assemblies and senates, request comparative briefs from our table officers, identify gaps within our national frameworks, and initiate the necessary reforms. Through this, we can ensure that the standards we set here translate to real protection and opportunities for our citizens. Colleagues, equality is a right and must be realized in every country on our continent. I appreciate the committee and all the contributors for advancing this important work. Let us move together from policy to implementation, from PAP to the national parliaments, to deliver meaningful change for our people. I thank you.
Merci, l'honneur.
Thank you, Honorable. I would like to give the floor to Honorable Leo Kadi Ndakaisaba from Burundi. Thank you, Honorable Chairperson, for the floor. I would also like to contribute to this debate, which is a very important one. Women are still asking themselves the question why this discrimination subsists between women, young girls, and boys. We're still wondering why these differences subsist, but yet being born a boy or a girl is beyond our control. This is not something that we can choose, to be born a boy or a girl. We also wondering when boys and girls are together, sometimes women tend to perform better in school, but when it comes to employment opportunities, boys tend to have first preference. Being a young mother is an important issue, and we would like to commend the countries that have made progress in that regard. Countries that have already implemented quotas for women representations in public office. I would like to take the example of our country, Burundi. 30% of positions are reserved for women in public service and all other public administration institutions. We also encourage women to submit their candidacy for other important positions, and we also encourage young girls to study science, mathematics, ITC, and engineering, etc. We also encourage women to join cooperatives and associations to enable them or to empower them. What we've observed is that the women population is higher than the population of men or boys. The lack of opportunities to earn a revenue makes the lives of families very difficult. And this pushes women to engage in promiscuity and to give birth to children out of wedlock who are not raised in proper families. So we support this model law in order to promote proper family values and puts an end to the suffering of children who sometimes are left abandoned. In addition, we have a vulnerable population. We have old people who need protection as well. And in Article 62, which refers to old people, I think we should add these care centers for old persons, which would be quite beneficial to people of that group. Thank you very much.
Honorable.
Thank you very much, Honorable. Now, I'd like to give the floor to Honorable Adlet Borges from Angola.
Muito obrigada. Thank you, Vice President, for giving me the floor. Ladies and gentlemen, distinguished colleagues, it's with great honor that I speak to you to talk about an achievement that did not come by chance, but by a very hard work, committed and conscious that was made by this committee. During many months, we gathered knowledge, we heard different opinions, and we faced obstacles. And we built together this model law on gender equity and equality in Africa. So this instrument is not only a compilation of articles, it's a pact with justice. It's a direct response to historical inequalities suffered by many women and girls in our continent. But our effort will not bear the fruits if this law will remain the way it is. And I must repeat, this will not be worth it if we keep it like this. And we hope and we call all our member states to implement and transform this model law in national laws, in concrete laws, in real policies and positive changes. And I believe that it's possible to do this. Gender equality cannot be postponed. The time for action is now, and this law is our opportunity for justice, opportunity for coherence, and also for Africa. Thank you.
Merci, Honorable.
Thank you very much, Honorable. I would like to give the floor to Honorable Tijani Yaya from Chad. Thank you very much, Madam Chair, for giving me the floor. Before adding my contribution to the debate, I would like to congratulate all the members of the Gender Committee of the African Union, in particular the Vice Chairperson of the committee, Honorable Adija, for this very succinct report on the model law on gender and family. A model law is a good reference document that states can adopt to harmonize their legislation. I take the floor today, Madam Chair, to express my support to express the support of the caucus that I represent for this law. Our caucus is committed to protecting the rights of women and to also advocate with our national assemblies for the ratification of this continental legislation. This draft legislation is very important to strengthen equality and inclusion on the continent. It is our daily commitment to advance this cause through collaboration among all parliamentarians and also through collaboration with our partners. This draft legislation is a great step forward for the African continent, and that's the reason why we are in full support of this draft legislation, which takes into consideration various dimensions of the rights of African women. And it also takes into consideration the issue of equality, non-discrimination, and the right to human dignity, the right to life, and protection, justice, political participation of women, as well as the promotion of equal opportunities. And in addition, we have equitable access to education by our young girls on the continent, and as well as equitable access to economic opportunities. My colleague earlier highlighted these issues that are quite critical for the empowerment, the economic empowerment of women. And this draft legislation also takes into consideration the employment of women. Without further ado, Madam Chair, I'd like to ask all my colleagues present in this room to give their approval for the adoption of this draft legislation. Thank you.
Thank you, Honourable Chairperson. I would now like to give the floor to Honourable Tabiso Likitla from Lesotho. Sorry if I mispronounced your name, Honourable.
Thank you so much, Madam President, for the opportunity. I would like to start by acknowledging the importance of gender equality and equity as a key pillar of democracy, justice, and sustainable development. Honorable members, through you, Madam President, the empowerment of women and protection of vulnerable groups is not our favor. Or it's not a favor, but it is a basic human right. Honorable members, through you, Madam President, society that treats women equally grows stronger economically, socially, and politically. But across Africa, the promises has not been fully released. Women remain underrepresented in leadership, face barriers of unemployment and political participation, and experience discrimination that limits their fully potential. I think we should start before we adopting this model law by reflecting ourselves. Honorable members, through you, Madam President, does the House fully respect gender equality and equity in its procedures? In the leadership positions, in the committees, are a woman's contribution given equal weight and authority? This law asks us not only to pass rules, but to live by them in every aspect of our work. You must ensure our debate allow all voices to be heard, honorable members. The leadership reflects the diversity of our society and that our priorities consider the realities of women, girls, and marginalized groups. Honorable members, equality is measured by practice. In the role we assigned and the time we allow for contributions and the respect we gave to all members of this House. By reflecting honestly, we hold ourselves accountable. And the House has the chance to lead by example, making gender equality and a culture we live, not just a law. The equality demands continuous effort, vigilance, and courage. Honorable members, through you, Madam President, over the years, this House passed several laws and frameworks aimed to promoting gender equality and protecting the rights of women and vulnerable groups. But yet, regrettable, many of these laws have remained largely dormant, shelved, or poorly implemented. This is not a mere technicality. It is a profound failure, because laws that exist only on paper cannot protect, empower, or transform lives. Shelf laws deny justice, weaken public trust, stall progress, and send a message that rights and equality are negotiable rather than non-negotiable. Honorable members, through you, Madam Speaker, the failure is not a reflection of quality or intent, but of political delay, weak follow-up, and limited enforcement. Honorable members, similar, at a continental level, African Union has developed model laws to promote gender equality, yet many of these too have been passed but left unimplemented. This mock law, however, provides a clear and actionable framework to address these gaps. It ensures equal representation of women in governments and leadership. It protects women and girls from discrimination, harassment, and violence. It promotes gender sensitivity policy in education, health, and economic participation. It set up a clear system to monitor and enforce equality. Honorable members, through you, Madam Speaker, to make the law effective, I appeal this House. This House must commit to the time-bound national implementation plan. Set up a gender equality oversight committee and launch parliamentary-wide training on gender-responsive legislation. These steps will turn law into real change, both in Parliament and across our countries. Madam President, this approach also aligns with our protocol and gender development, which calls the equal participation and protection of women into the SDGs 5 and 16, which promote gender equality and strong institutions, which apply stage to eliminate all forms of discrimination against women. Madam Speaker, at my conclusion, adopting this law is not an end. But the beginning of a journey to a house, a nation, and a continent where gender equality.
Thank you, Honorable.
Just a minute, Madam Speaker.
You have 1 minute to conclude.
Thank you so much, Madam Speaker. Adopting this law is not an end, it's the beginning of a journey of this House, a nation, and a continent where the gender equality and equity are really and lived every day. Let us be bold, unshakable, and committed. Let us not just pass a law, but show this House is worthy to the trust of the citizens, women and men alike. Thank you so much.
Merci.
Thank you, Honourable. We have 2 speakers remaining, and I hope that we can conclude very shortly afterwards so that we can adjourn for lunch. I give the floor now to Honourable Leila Day from Morocco.
شكرا سيدة الرئيسة.
Thank you very much, Madam Vice President. I would like to express my gratitude to the Pan-African Parliament and the committee. I think it's so important that the Pan-African Parliament is discussing such a historic model law on gender equality, which can be so beneficial for the African continent. And it contains all the commitments made in the Maputo Protocol and the Charter of Human Rights, Human and People's Rights. And this is the first time that we are discussing a model law on gender equity and gender equality. So it is indeed a crossroads. I would like to thank Madame the Dao Bala, the chairperson of the committee, as well as the vice chairperson, the bureau, and all committee members for all the hard work that they have put into this model law. I would like to also express my gratitude for the fact that I was able to participate in one of the consultation processes here in South Africa, as well as another consultation process in my region. And as I am a member of the Youth Caucus of the Pan-African Parliament, I believe that I was able to, and other young members were able to contribute to this model law. And it is so important for women and the youth to be represented in decision-making processes. And I am so pleased to see that sexual and reproductive health have been taken into consideration, the protection of women's rights, and this model law is also going to improve women's participation in education, in politics, and in the economy. It also takes into consideration social and cultural aspects that hold women back. And it is very important for me that the issues of rape, sexual violence, and harassment have been taken into consideration and covered in this model law. I am just disappointed that this room is not full of MPs in order to be able to applaud this model law and approve it. And the gentleman who spoke before me spoke for a very long time, and I would have liked to have been able to speak for a little bit longer to a wider audience, because this is such an important model law that will give dignity and legitimacy to women across Africa, and will defend the interests and the rights of women who are such a source of life, work, inspiration across the continent. I would like to thank the committee once again for the work on this model law, as well as the partners and our legal expert, Mr. Clement. Thank you for the presentation, Monsieur Clement, which was very clear. The civil society in Ghana also participated in the consultation process, and I thank them for their contribution. And I'd like to thank the other MPs for their contributions as well. This model law will really show that the Pan-African Parliament is ready to be a legislative body. Thank you very much. Thank you very much, Honorable Leila, for these very sweet words. And I'm not at all surprised because you are such a sweet person. I would now like to give the floor to Honorable Viva Baira, who will be contributing via Zoom. Honorable, are you online? Technicians, please can you assist us? The last speaker is an Honorable MP who is online. Okay, she has the floor. Thank you. Honorable, go ahead.
Yes, yeah. I appreciate, first of all, PAP leadership for affording us to follow online. I am an MP from Rwanda. Can you hear me?
Yes, we can hear you, Honorable.
On vous attend, l'honorable. Continue.
I appreciate also the Gender Committee of which I'm a member. I just want to give my humble contribution about gender. As you're aware, Rwanda has championed gender equality. And I want to record, I want to just add to the words that our president says, the statement, beginning that statement saying, women and men are equal in terms of ability and dignity, and they should also be equal in terms of opportunities. As Rwandans and as Africans, we need every member of our society to use his or her talents to the fullest if we are to reach our development goals. So I was echoing that statement of our President Excellence Paul Kagame talking about gender equality. And Rwanda, as well aware, we have been able to champion gender equality, and we have very good numbers even in our beginning with our parliament. We have the parliamentarians 50% in the Senate, that's the upper house, and 63.75% in the parliament are all women. And very many other important positions are occupied by women. And gender in Rwanda means all men and women are equal. And so, and because of the genocide, very many women were affected. So promoting women was seen as an opportunity to revitalize the country, the nation, to make it move forward. Because to the leadership of Rwanda, gender equality, that is promoting women and men, girls and boys at the same level, means development. It's not a favor to women. And this was able to be achieved because of the political will at the highest level, gender responsive legal framework in the constitution, the policies and programs, they were all able to be drafted and strategies put in place and institutional framework. So I wanted to add my word to my colleagues who are saying that gender should be promoted in Africa, and the gender law, the model law that was presented today, actually it's not only about women, it's about men as well, and girls and boys. So I submit my voice saying it's possible to promote both men and women. It's possible to overcome traditional barriers and cultural barriers that have been put on women historically and move our nation forward. I thank Your Excellency.
Merci.
Thank you, Honorable. Even though you are not here with us today in Midrand, we are very pleased that you were able to participate online in this debate. I would now like to give the floor to Honorable John Bonas Bidera from Rwanda. I hope that you can be brief, please, because we need to adjourn for lunch soon. I'm counting on you to be brief. Thank you.
Thank you, Your Excellency, for giving me a last-minute opportunity. I'm very grateful that my colleague, Honorable Jennifer, has made her contribution on this model law on gender equality and equity. It would have been very unfair for me not to support this model law, looking at the fact that my country, Rwanda, is one of the pioneer countries on the continent that is promoting gender equality and equity. I'm not going back to the statistics, she has already mentioned them, but I want to say that what is very crucial here is not just having the laws and having the policies, but it's very important to have a political will. Political will is very necessary because we can have good laws, we can have all these representations factored in the Constitution, but we also know that if the leadership does not support that, then you cannot go very far. But I want to say that I'm very impressed with the work that the committee has done. It is indeed a futuristic law, it is very timely, and I think it addresses all the issues that concerns gender equality and equity. And therefore, I want to end by saying I support the model law on gender equality and equity in Africa. Thank you, Your Excellency. I submit.
Merci, Honorable.
Thank you, Honorable, for having been so brief. And thank you for taking the floor to support your colleague and also speak to us about your country, which is a leading country in terms of defending women's rights, in terms of the number of women in your parliament and in your public administration. You are a model country, so thank you. We are going to give a last word to Honorable Fatimata Njay from Gambia. Honorable Fatimata, we hope that you can be very brief so that we can give the floor back to the Vice Chairperson of the committee so that she can respond to some of the comments made by our honorable MPs. Madam Fatimata, you have the floor.
Thank you very much, Madam President. And I think it is a day for us to celebrate today, having done so much work on this. And first of all, I would like to thank the committee clerk, Maribibi, and the chairperson of the committee and all committee members for all the efforts they have given, and also to thank the Bureau for the support. But also, this is just a model law. A modern law is just a model. We need to take it back to our home countries and make sure that it is implemented in our domestic laws. In the Gambia, for example, we are working on a constitution amendment to have more women in parliament, and we need the support of every member country to make sure that we push our government for that bill to pass. So this is a continental parliament. The whole of Africa is sitting today discussing women issues, and we need the whole of Africa to support in women and youth empowerment. So that was my contribution, appealing to members to pass this, and not only that, to push our respective countries to domesticate this modern law. Without it, it would just be a piece of paper on the shelf. Thank you so much, Madam.
Merci, Honor.
Thank you, Honorable Fatimata. And I'd like to thank all MPs for having stayed in the room for this very important debate, a debate that concerns everybody, not just women. I would also like to thank the Committee on Gender, Family and People with Disabilities and for all the hard work put into this model law. And without further ado, I would like to give the floor back to the Vice Chairperson, Honorable Khadija, to respond to some of the comments and questions.
شكرا جزيلا السيدة الرئيسة.
Thank you, Madam Chair. I won't prolong my speech. The MPs were committed by attending at 9. That's why we are on time today. I'm very proud. At this juncture in history, I would like to thank you, and I would like to thank Mrs. Miriam Dobala and all the people who are following up through Zoom, although the circumstances could not allow them to attend with us here. So that's why they are following us from remotely. I would like to thank PAB Chair, the chair of the PAB and the clerk, and the technicians, and ladies and gentlemen, my colleagues who have taken part in the birth of this legal platform. And I would like to thank every mind that contributed to writing the articles of this law, and all the countries that have hosted us, and all the civil society that was very present, strongly present, at the revision and perusing of the items of the law. It is true that we may face some difficulties or some objections from some countries. So please, I urge all of you to adopt this law, because this modern law does not mean only women, but it means our society, the African society, that we want to elevate
And it is true that we may face some reservation from some country, but this should not sway us from adopting this just law that is concerning entire society, and that after its adoption, then its ratification, and then it will achieve our political, economic, social, cultural rights for us all. So we have to follow up the implementation of this law after ratification. As Madam Chair said, it is not about writing these laws, but it's about how to respect and follow and implement them. Today, I'm very happy, as I said, and I would like to appreciate the effort of the African Union, the African Parliament, and I would like to pass the floor to Mr. Clement, the legal advisor, to share with you all the amendments that you contributed, and so that it should be assimilated into the law, into the model law. Thank you very much. Thank you, Madam Chair, for these observations and the efforts that have been exerted for this important law, which is important for all of us. And I would like to remind you all that Honorable Mariam requests intervention. So let's give her the floor so that she can express her view in 1 or 2 minutes. Thank you.
Vous avez la parole pour.
Honorable Mariam, you have the floor for 2 or 3 minutes at most. You have the floor, Honorable Mariam.
Est-ce qu'elle est en ligne?
Is she online?
Elle a la parole, Anaka.
She has the floor.
Elle ouvre son micro.
Please turn on your mic. There should be a problem. Well, while waiting to tackle this issue, we're going to give the floor to Mr. Clement. He has just 2 minutes because he has already been here. So he's just taking into account the observations made by the honorable MPs that will be incorporated into the final report. Thank you.
Honorable Chair, I will just address 3 issues quickly. There was an issue raised in relation to the quotas. I think it was Honorable Senator Mongatana proposing 30% men and women, and for either gender, and 10% youth, which is a very good proposal. But I noted that in Article 15.2.3, III, the model law actually sets a higher standard. It is 50%. And I think this came from the consultations whereby it has to be equal, 50-50. And for the youth, it's 30%. But I still take note of the fact that what the Honorable proposed is a minimum, and I think it's still an idea that can be accommodated. Then another issue by Honorable Dlamini in relation to same-sex marriages. I must say that it's clear that same-sex marriages are not part of the model law. But I think where there could be some ambiguity, we may need to basically make it clear. But reference to all types of marriages here refers to civil, customary, and religious marriage. Your proposal to probably define marriage could probably allay those fears. I think we could insert a definition. And the second issue on children's education to health and sexual reproduction, it's also a legitimate fear, but Article 45(2)(1) qualifies it to say that this education must be age appropriate. And I think that core word is guiding what this type of education could be like. And lastly, there was a proposal to consider accommodating older persons in centers. It's something which could be added, although Article 64 talks about reasonable accommodation. But I think we can try and be precise to integrate this idea of particularly where older persons may not have a family where they could be reasonably accommodated. Centers could probably be useful. Merci beaucoup, Honorable Présidente, de m'avoir accordé la parole.
Monsieur Clément, je pense qu'on doit...
Mr. Clément, I think we now have to move on to the adoption of the report, because if there's not objection, can we consider that the report is adopted by the plenary? Thank you very much. And I'm now going to give the floor to the Deputy Clerk if he has announcements. Otherwise, we have to reconvene at 3 p.m. Thank you. There are no announcements, so let's reconvene at 3 p.m. I count on you to be punctual and present, because the next report is as important as this one. Thank you very much.
C'est bon.
she behind? Honorable members, the third vice president. Sorry, the first vice president.
Bonsoir tout le monde.
Good afternoon, everyone, and thank you for returning and giving us the opportunity to proceed with our deliberations for today. I'd like to give the floor to the Deputy Clerk for the agenda. Thank you, Honorable President. Now we're going to have the presentation and debate on African Credit Rating Agency. This presentation will be done by, or supposed to be done by Her Excellency Ambassador Marie-Antoinette Rose-Cartre, the CEO of the African Peer Review Mechanism, but who will be represented presented by her representative. Thank you. So without further ado, then, I'd like to invite the representative of Her Excellency Marie-Antoinette Rose-Cartre for the presentation that she was supposed to make. Thank you.
Good afternoon, everyone. Good afternoon. That's better. My name is Jigayo Tafara, and I'll be speaking on behalf of the APRM CEO, Her Excellency Ambassador Rose-Cartre, who unfortunately was not able to join this sitting. Honorable Vice President of the Pan-African Parliament, honorable members of the Parliament, distinguished delegates, ladies and gentlemen, it's a great honor and privilege to brief you on the establishment of the African Credit Rating Agency. It is a very critical initiative that has been spearheaded by the APRM following the Assembly decision back in 2017 to provide that requested APRM to provide support to African Union member states in the area of credit rating agencies. And this mandate was emanated from the various concerns that African member states have been raising in different platforms with regards to the rating that they have been receiving from the three dominant rating agencies, which in most cases wasn't a reflection of their economic development status, the economic growth, and most of the positive, development that has been noticed and that has been recorded among African countries. Since the first country who has received rating, that was South Africa back in 1994, the number of downgrades are more than upgrades in Africa. And Excellencies, you will understand that credit ratings have got far more implication in terms of countries' ability to access capital, as well as the cost of borrowing, and their ability to attract investment, and their physical space to be able to, to spend in social services. So, due to those concerns that have been raised by African Union member states, APRM, as part of our economic governance and management mandate, was given this extension of our mandate to support African Union member states in the area of credit ratings. Since the mandates were given to APRM in 2017, the APRM developed a policy framework that has 4 components, out of which one is a component on the African Credit Rating Agency. The other components include research and advisory, capacity building, and also we also have a network of national regulators of the capital markets who come together 2 times a year to see how we can harmonize regulations across the board when it comes to regulating the credit rating markets on the continent. So one of the pillars of this framework was the establishment of the African Credit Rating Agency, which was further endorsed by the 6 specialized technical committee on finance, monetary affairs, economic planning, and integration. In Nairobi, that was convened in Nairobi, Kenya, back in 2023, and endorsed the establishment of a private sector-driven African credit rating agency based on self-funding and the challenge of rating agencies. We know that globally, 90% of the rating market is dominated by only 3 rating agencies, and we all know that monopoly is not good for consumers. So there wasn't an alternative opinion to the ratings that many of African countries have been receiving, and that was a concern that was shared by African countries. Furthermore, there was also concerns to do with the rating model and the methodology that was adopted by these rating agencies that doesn't take into account the bulk of African economies, such as the informal sector, which is significant in many of our countries, but not being able to capture in any way in the estimation of the ratings. The other issue has been pessimism. There is subjectivity that is also in the rating analysis, and most of the rating analysis and opinions that are issued in the continent are quite pessimistic, and they do not reflect the positive achievements and the positive growth stories that Africa has been showing. Have indicated the issue of competition in the market, and I have also, I think, talked about the independence issue, which is also, we have been mentioning the issue to do with Ukraine and Russia war. When the war broke out between the 2 countries, rating agencies withdrew their rating from Russia, and we asked the question: if you are an independent and if you are free from political interference, why are you part of the sanction package that is being proposed by Western countries? So these are some of the challenges that were highlighted in the existing rating space. So what was the case for African, that was also part of the case for initiating an African credit rating agency. Subsequent to the decision to establish the African Rating Agency, the APRM and our key partner, the UNECA, we have been conducting quite a rigorous exercise in terms of understanding the market and the feasibility of establishing such an institution. And we have also been able to identify what is the niche or the business case for the establishment of the credit rating agency. One is the market. There is untapped market in on the continent. Out of 55 member states of the African Union, 22 African countries are still unrated. There are also over 90% of African corporates and municipalities who have not been rated. And this is quite a significant market potential for the African Credit Rating Agency to be able to penetrate and be able to support. And that will also be able to unlock so much of the domestic capital, which is currently not liquid. The other business case for the African Credit Rating Agency is the African countries wanting to have alternative opinion of, or any different opinion from the big three. And we also believe that AFCRA will be a means for continental integration and socioeconomic development through its ability to be able to mobilize domestic resources and be able to, develop our own capital markets continentally. These are some of the headlines that I thought I would share with you in terms of, the African Credit Rating Agencies being established and some of the news and, that has been shared across the board. In terms of the update on the implementation of the Executive Council decision, since that decision was passed, APRM has conducted technical consultations with the regional rating agencies, African credit rating agencies, as well as other financial institutions, including the African Development Bank and the Afrexim Bank. We are also collaborating with the African Development Bank and the Afrexim Bank. We have set up actually an advisory committee that is helping us to oversee the operationalization of the African Credit Rating Agency. This is the proposed legal structure of the agency. There will be a complete autonomy from the African Union. It will be established as a private sector entity. And this is done so in order to protect the credibility and independence of the institution. It will have its own ownership and governance structure, but AU will provide that recognition so that there is an uptake of the services that are being provided by the rating agency. And this is the shareholding model that we are currently working on. There will be 3 classes of shareholding. One by Pan-African multilateral institution, 2 by domestic and regional rating agencies, and the third one is international investor as a minority shareholders of the rating agency. This is just to give you a snapshot of the proposed structure model that we're working towards setting up. So in terms of the financial model, it will be funded by the shareholders through equity capital. It will be self-sustaining, generating revenue by the services that it will provide, and there won't be any subventions or contribution from member states. The other major development in terms of the operationalization of the African Credit Rating Agency is that we had conducted a comprehensive and competitive bidding process that was administered by a transaction advisor who is now helping us in the setting up of the rating agency. And Mauritius has been selected as the primary jurisdiction. I just wanted to highlight that primary jurisdiction. It's the first country that will register the African Rating Agency, but other secondary jurisdiction will also be considered as we go along. And we hosted the ceremony of announcing the first jurisdiction on the 7th of October in Mauritius this year. So going forward, in terms of the roadmap, we have done pretty much most of the groundwork. And we're now at the stage where we are finalizing the shareholder agreement. We've done the institutional consultations with strategic and Pan-African financial institutions. We have appointed an independent transaction advisor who is now facilitating the establishment and institutionalization of AFCRA. We have concluded discussions in terms of the seed funding and the operational funding of the agency with the African Multilateral Institution. We're at the stage whereby we're now looking at the shareholders agreement and the shareholding model. And we hope to convene the inaugural general meeting of the shareholders early next year, followed by licensing and registration, at least in Mauritius, also early next year, and hoping that the agency will be able to issue its first rating on 30th of June 2026. So this is the roadmap that we hope to implement going forward. And we will come back to this chamber at the later stage to provide you further feedback on the progresses that we have made in this regard. I thank you for your attention.
Merci beaucoup pour.
Thank you very much for this brilliant presentation. Unfortunately, we do not have the printed version of the presentation that could have helped the MPs follow more conveniently and probably prepare their interventions or questions or comments. If you could perhaps forward the presentation to us electronically so that we can circulate it or distribute it to the honorable MPs to help them formulate their comments and questions. Thank you.
J'ai ici une liste de.
I have before me a list of interventions, and I'm assuming that the speakers would be willing to speak on the presentation that has just been made now. Honorable from Senegal. Thank you very much, Madam Chair, for the floor. I would like to start by congratulating the APRM for this very relevant presentation that they have just given us. I think the idea of a rating agency for Africa is welcome for African economies. I had a question to ask, but before that, I would like to remind that, as our presenter mentioned, that Africa is currently facing a number of challenges in terms of the ratings given to it by other countries. These ratings usually do not take into account the economic, social, and financial context of the continent. And if we could put it bluntly, our countries are underrated. And as it was mentioned earlier, when an international institution that does not know the context of the country is given the responsibility to rate its economy or its economic performance, there is a problem. And therefore, this African Ratings Agency is quite relevant. However, my question is about the dispatching of the stakeholders. If we are talking about a ratings agency, we have stakeholders such as the Americans, the French, and all the great powers of the world. Are we going to follow the same format as the existing rating agencies of the West? Now, if the main shareholder is not an African, it's not an exclusion measure. Would we not find ourselves with another ratings agency which would not truly, which would not be truly an African ratings agency? Is it going to function in the same manner as the existing ratings agency? Have you taken into consideration these various aspects? I believe that they are important because if the heads of state approve this project, the objective would be for African countries to finally have an agency that takes into consideration its own context. So if Africans are majority shareholders in a ratings agency that will not take into consideration what truly affects them, would we not find ourselves with another agency that definitely does not take the context of the continent into consideration? Madam Chair, I would like, Madam Chair, the presenter has just reminded us that to date, we have almost 22 countries that have not been rated and a number of municipalities as well. In relation to that, based on the diagnosis that you presented, what is the strategy that you have devised? Before becoming an MP, I am also a mayor of a rural municipality, and should we not know what would be the pillars of this ratings agency? And the municipalities usually do not have 100% control of their budget, and these are issues that should be raised and debated in institutions such as the UEMOA Collectivities Council, the WAEMU Collectivities Council. If there is groundwork that was conducted, I would like to know how it was done, and if not, I think it should be one of the recommendations here. Thank you very much, Honorable Chair, for the floor. Thank you very much, Honorable, for this brilliant intervention. Now, I'd like to give the floor to Honorable Estelle Ojono Pasari from Kenya.
Members, first I want to thank the presenter for the insightful presentation. As we discuss the Africa Credit Rating Agency, we must confront one central truth. This agency will only succeed if it earns strong, deliberate, and collective buy-in from the governments, our private sector, our regulators, and our investors. Buy-in is not a procedural issue. It is a lifeline of this institution, because without it, we will continue to rely on the same three global agencies whose methodologies, biases, and geopolitical positions have disadvantaged Africa for decades. Legitimacy and credibility is important because the world will only take the Accra seriously if Africa takes Accra seriously. If our own governments continue to default to the big three international markets, we'll ask, if Africa don't trust their own institution, why should we? Buy-in signals confidence, sovereignty, and ownership. Markets uptake and usage. For Accra to function, it needs clients, sovereign corporates, municipalities, banks. If these entities do not adopt the Africa rating as an equally credible measure, the agency will not scale up, no matter how strong its technical framework is. The business case depends entirely on the widespread adoption within the continent. Today, when the global rating agencies downgrades one African country unfairly, the spillover affects the entire region. A strong Africa agency gives us something that we have never had before, an alternative, evidence-based African voice to counterbalance those opinions. But that counterbalance only works if our stakeholders stand behind it. Investors rely on ratings because they reduce information asymmetry. If Accra is backed by the AU member states, African multilateral institutions, and private sector players, investors will see it as a credible, stable, permanent feature of the African financial landscape. Buy-in reduces perceived risks. Honorable colleagues, buy-in is not optional. It is the determinant for success. Without a unified political will, private sector participation and regulatory alignment, Accra will remain a concept. With buy-in, it becomes a tool for economic justice, financial sovereignty, and a balanced global financial architecture. Let us therefore commit, not in words but in practices, to supporting, using, and elevating the Africa Credit Rating Agency. I thank you.
Merci beaucoup.
Thank you very much, Honorable Essel, for your intervention. I would now give the floor to Honorable Senator Ndakana from Kenya.
Thank you. Thank you very much, Your Excellency, for giving me the floor. Your Excellency, a few years ago, Kenya was given a very poor rating by the three big rating agencies of the world. But recently, Kenya has been upgraded by Moody's from B- to B+, meaning that although it has its own challenges, they have placed Kenya at a position that it can meet its obligations. And the reason they did this was because by July, we had reserves from the Treasury equivalent to 11.2 billion US dollars. Now, a lot of countries, especially within the eastern area of the continent of Africa, know that Kenya has been a very strong economy for a very long time. And when we do our budget, the East African countries, you have to combine almost all of them for them to reach the budget that we plan for in Kenya. And yet, we have to go back to a European credit rating for them to tell us we are good. And not just Kenya, but other countries in the north. It doesn't matter how well, how nicely you're doing your things, you have to go back to them in Europe, in America. And remember, these are not government agencies. Moody's, Fletcher's, they are not government agencies. These are private agencies created by people. And you pay a lot of money in dollars to get your country credited or rated. So some countries even don't go for these ratings because it's too expensive for them to pay. So many countries in Africa are not rated. And as a result, when people want to invest from outside, they go and ask, is this country a good country to put my money in long term? And they are told, no, that country is not even rated. So again, you deny countries money that could go in because of some Europeans who are sitting, Bazungu sitting outside and rating us Africans without even knowing the conditions of how African states operate. They have zero knowledge. They were not born here. They look at us from the Google Maps to locate where our countries are, And they are the ones who are giving us the rating, how your country is supposed to be performing economically. So I am 100%, honorable members, supporting what the African peer review mechanism has decided to do. The African rating agency should come like yesterday. We should support it 100%. We should go with it, because if another brother comes to me to rate me, he knows the kind of political situations we are in, the kind of rains we are receiving, the kind of infrastructure like roads we are having. They are able to tell you that your country is good to go, or you need to improve this and that. But a European who has never come to Nairobi all his life, and then he comes to rate the whole country after just studying it for a few months, I think it's a very unfortunate situation. This is similar to the fact that we have pushed for the African Development Bank to come into being. Because African Development Bank, when you go to borrow money, it is different from the World Bank. It is different from IMF, because they are able to understand us better than those other multilateral donors which are not African-born. So I think that now we have the African Development Bank. It doesn't matter what challenges it has done great projects for Africa, which World Bank had refused to fund, which IMF would never even consider, but it has funded some very big projects, infrastructure projects. Now, we have finished with the side of the bank. Now let us go to the side of rating our countries as Africans. It is time for us to support what the African Peer Review Mechanism has done. It is time for us to stand with them. And I think this African credit rating should come like yesterday, so that African countries can have a framework within which we can look at ourselves and say, you are doing better this year, and look at ourselves, or you have reduced from last year. Because if a man from Zimbabwe comes to Kenya and tells us, no, your crops are failing, I will understand him more than a person who uses bulldozers and whatever to mechanize thousands of acres, who is coming to rate me. So I would understand a person from Uganda to come and look at our economic situations better than a European. So I think we should really support this. I think this is one of the biggest innovations that the African Peer Review Mechanism has come up with. And I call upon you, colleagues, to support it, to support it, to support it. I submit, Your Excellency. Thank you very much.
Merci beaucoup.
Thank you very much, Honorable MP, for these important clarifications. I think they confirm that Africa can only achieve development through the efforts of its sons and daughters. Now I call upon Honorable MP Philipso Wido from Namibia.
Good afternoon, fellow Africans, honorable members. A very short intervention is maybe to echo the sentiments of Professor Samatar. I think he left. I think documents are of paramount importance for us to be able to make meaningful contributions so that we comment from very much informed viewpoint. So the release of documents is cardinal. I think he raises that point earlier. I just reiterate that fact. However, I also acknowledge that after the chairman's intervention, the document was then sent on the PAP platform. But some of us are not geniuses to be able to scan through. Now, having worked through the document, I discover one aspect which I want to inquire is why is the African peer review mechanism a voluntary association from African states if it's about cardinal importance in terms of data and statistics to which we need to comply. And it deals with a cardinal matter of democracy and political governance, economic governance and management, corporate governance, and socio-economic development. Those are the key fundamental aspects on which a state can improve the living conditions of its citizens. So my first idea is to say why do we make it voluntary and how do we make it mandatory for every African state to be a member so as to help guide in terms of the improvement and reliability of key decision matters that emanate from statistics and data. The other cluster I want to understand, in the classification of investors, class A, B, and C, you find that class C is international African investors, both African and non-African. I mean, borrowing from the last speaker, who was saying it will be better to understand crop failure from somebody in Africa. Why do we have that privilege and advantage extended to or classification between an African international investor and a non-African international investor? I mean, it's fair and just to say, as Africans, we should be able to look after each other and have got penetrative or structural measures in which how we improve trade between African states, trade between the promotion of African investors, and even giving them that, if I may call it, biasness in terms of assessment. We can't assess an African international investor the same way we assess a non-African investor. We need to have an element of safeguarding our own interests and having a favorable approach towards Africans and the African development. Because that is why has caused this creation of this peer African review. It's because we realize that in terms of the current status quo, the African perspective is not taken care of. So I've just highlighted one because I just saw the document, but I thought it should be the line of thought going forward that we should have, and we should favor ourselves as Africans. Nobody is going to do it if we don't do it for us. Then lastly, I really take note, the roadmap that is there was set up by us, for us, and let us adhere to that roadmap, which means by coming next year, less than 6 months, roughly 7 months from here, 30th of June, 2026, the new rating agency of Africa should be fully function. I think the launch is scheduled for 30th of June. I know people, we like African time, but let's set targets and let us be the one that foresee that those targets are met. So I want to submit that when I come back next year, God's grace, I should be able to, by the 30th, I will not follow anything, but I will wait and pray for the 30th of June. And by that date, at least in terms of the commitment and the target we have set ourselves, the African Credit Rating Agency should be fully functioned as of the 1st of July, 2026. So I submit and I thank you.
Merci, Honorable.
Thank you, Honorable MP. I'm going to give the floor now to Honorable MP Swaibu from Gambia.
Thank you very much, Madam President. Madam President, for Africa to have an independent, credible agency, which is solely owned by Africa, I think that is a very welcome idea. An agency that will be trusted which will provide accurate information regarding the wealth of our countries and our ability to lend. What comes to mind is that when I raised this issue in my parliament with my finance minister, he said they were not ready for credit rating, even though they know Africa now has credit rating. He raised the issue of cost, that it is not free to do that. That it is very expensive to involve credit rating agencies. And also that since they are not dealing with, I think, multilateral lenders, they are dealing with bilateral. For now, they are not yet ready for credit rating. But my question is, for example, what the presenter was saying, that the other credit ratings, Standard Poor's, etc., Moody's, they try to ignore some of the wealth that we have to give us lower rating. What comes to mind is that what type of items usually do these outside credit ratings ignore to the disadvantage of the African countries? That is one question. Also, I want to also know whether this African credit rating agency will work independently, or would it be collaborating with the three big agencies that will also boost or support their opinions so that countries can give? Because what Honorable Esther from Kenya just mentioned, that if those people, those other agencies come back again and discredit you, let me say it that way, it can affect the whole region. So we need to be thinking about those things. On that note, thank you very much. Thank you.
Thank you.
Thank you very much, Honorable MP. I now give the floor to the Honorable MP from South Africa. I apologize if I mispronounce your name, Momiseni Multi, South Africa.
Madam President, and don't worry about the pronunciation of my name. It doesn't matter as long as I know you wanted to pronounce it correctly, so it's okay. I think essentially I've been broadly covered by the rest of my colleagues who spoke earlier about the need and the importance of having an African rating agency. I mean, I know in my own country, we've had very bad experiences with these Western rating agencies, making interventions that have really not been helpful, and in many respects, leading us to come to conclusions that these rating agencies are not only conducting their businesses objectively and consistent with what they do in the rest of the world, but they are driven by certain political considerations. Because as much as they are not owned by governments in the countries of their origins, but there's no doubt in my mind that in one way or the other, they are heavily influenced by the work of the governments where they are coming from, or the attitude of the influential people within the state where they come from. So I agree entirely with, and I want to join my colleagues in welcoming the initiative as presented by the CEO of the APRM, which is an important step, a step in the right direction in my view. And I think we need to find a way in which we influence our countries to adopt this approach. But also not only to adopt it, but equally to understand that as Africans, it's important that we should have our own mechanisms and our own standard through which we can hold each other accountable for the success of the peoples of our continent. who are our own priorities and very important for us and for the development of our continent. Thank you very much, Madam President.
Merci,
Thank you, Honorable, for your kind understanding. I always insist on trying as much as I can to pronounce names correctly. It may take time at times. I do apologize again if I'm mispronounced your name and the names of other honorable MPs. I will now give the floor to Honorable Mabwa Ketlo from Lesotho. You have the floor.
Thank you, Honorable President, for giving me the opportunity to speak on the establishment of an African credit rating agency. The idea of an African credit rating agency is both timely and crucial for the continent's economic development. For too long, Africa has relied on external credit rating agencies to determine its creditworthiness, often to our disadvantages. Credit rating agency would allow us to take control of our economic narrative, highlighting our strengths and opportunities. With a deeper understanding of African economies and markets, it would provide more accurate and complex assessment of our creditworthiness. Furthermore, it would provide investors with more reliable and relevant information, increasing confidence in African markets. Honorable President, to move forward, we need to conduct through feasibility studies to determine the viability of an African credit rating agency. We must engage with relevant stakeholders, including governments, private sector players, and investors to build support and buy-in. In conclusion, Honorable President, an African credit rating agency has the potential to be a game changer for the continent's economic development. I urge this August House to support the establishment of such an agency and work towards making it a reality. Thank you.
Merci.
Thank you, Honorable. We have completed the list of speakers for this topic. And I would now like to give the floor to Madame Jigayu Tefara to respond to the comments and questions by the honorable members.
Thank you. Thank you, Honorable Vice President, for giving us the floor. And thank you for all the questions and comments that were put forward by honorable members. They are quite pertinent. And I would like to respond to some of the queries that were raised during the deliberations in the chamber. So the questions that were raised by honorable member from Senegal in terms of the methodologies of the rating agency. This rating agency will adopt a unique methodology which will be able to capture the African markets and the African economies and the nuance of African economies in a much more depth than the existing rating agency. And honorable members, I would also want to mention that to you that the methodology will be, standard, which will have to comply with international standard. That's also a way of ensuring that the rating that is going to come out of this agency is credible enough, but at the same time, it will capture the African market's realities in much better and more nuanced ways than the existing rating agencies. The question with regards to the unrated African countries, the 22 unrated African countries, the APRM has another support program that has been running for the past almost 6-7 years that targets countries, who have not been rated. And sir, I think that the honourable member from Gambia mentioned that his minister stated to him that the country is not yet ready for rating, but I'm happy to mention to honorable member from Gambia that Gambia is one of the beneficiaries of that support program that we had instituted with the support of UNDP and UNECA. And we hope we'll be able to, encourage and support Zambia through that journey towards getting a rating. The words of support from honorable member from Kenya, I think it's duly noted, and it is very critical that we give the buy-in for this institution, because we are the ones who give it a legitimacy if we want it to function to its optimal level. The other issues to do with, the analysts of the big three rating agencies who have not been to the continent and basically mostly, rate African countries from Europe, America, and, some of the Asian countries. These are some of the concerns that the APRM has been raising with the rating agencies during our meetings with them. It's important to highlight that it's only one rating agency out of the 3 rating agencies globally who has got an office here in Johannesburg. All the other rating agencies, they operate from their offices in Middle East and Europe. And we have told, and we have been insisting on that point, that analysts need to have more presence in the countries that they have, they are rating, to give them a more detailed understanding of, the structure of the economy and how it functions. That is part of some of our engagements that we have been having with the rating agencies, and we have been continuously raising that issue with the rating agencies. The roadmap on the implementation and operationalization of AFCRA, distinguished members, it's also our belief that we will be able to implement as it is, and we hope to come back to this chamber to give you an update at the later stage, possibly next year this time, on the finalization and full operationalization of the agency. There was also a question from, I think, honorable member from Gambia with regards to the areas that has been ignored by the big threes. There are several areas of inconsistencies when it comes to ratings that we have picked up. We have issued more than 22 statements to date, pointing out those inconsistencies during rating actions. And the other major issue when it comes to rating is the subjectivity aspect of it. It's not fully on the econometric fundamentals and the reserves that the country has, but it depends on also who's rating and what perception that a rating expert has about that country, which seriously weighs on the outcome of the rating action subsequently. Would there be collaboration with existing credit rating agencies? So far, the existing credit rating agencies have welcomed the establishment of African rating agency. Perhaps they have also seen that there is a gap that they have not been able to fill, and they are waiting to see the the operationalization of this rating agency. But we are also very cognizant of the fact that there has been anti-competitive moves by the rating agencies, particularly Moody's, who have been acquiring African-based, smaller African-based rating agencies. So we are very conscious about how we deal with the rating agencies. But yes, we have working relationship, and they are very much looking forward to the rating actions to come from the African Credit Rating Agency. I think those are the questions that I wanted to answer, but there is one question on the voluntary nature of the African peer review mechanism and why is it remain volunteer. So if you allow, Chairperson, my colleague Advocate Batluka would like to respond to that question. I thank you.
Allez-y en tant qu'équipe.
Thank you very much. Continue as a team if your colleagues would like to take the floor.
Thank you very much, Excellency, our President and Chair of this special session, Excellencies. So before perhaps I answer specifically the voluntary nature of the APRM, to emphasize the following points, Your Excellencies, that the UNDP report of April 2023, which was presented during the IMF World Bank Spring meetings, estimates the impact of biased credit ratings on African countries at $75.5 billion, Your Excellency, just to emphasize the point. And the report also has highlighted that African debt profile has surged by 183% since 2000, a rate 4 times higher than its GDP growth rate, most largely due to the biased ratings by the 3 dominant international credit ratings, Your Excellencies. And the African Development Bank has underscored that interest payments by African countries now constitute the highest and fastest growing portion of expenditure for many African economies, coinciding with downgrading of African countries and sovereign by African countries and sovereign ratings by African countries by the dominant international credit ratings, just to emphasize the impact of the credit ratings on our continent, Your Excellencies, in terms of figures. And as just to give a scenario, most of the African countries are rated at B+ or C by, say, for example, Standard & Poor's, which is S&P, which indicates a higher risk. And only Botswana, Mauritius, South Africa, and Morocco are considered investment grade with BBB or higher rating. These are investment grade countries on the continent. So you could imagine, Your Excellencies, that majority of our countries are at sub-investment. So to answer the question, Your Excellencies, of the voluntary nature, yes, the APRM, when it was established in 2003, it was established as a voluntary mechanism of the African Union that member states would join voluntarily to be assessed on the 4 thematic areas: political governance, economic governance, socio-economic development, and corporate governance. But the heads of state and government in recently, as far as 2017, they took a conscious decision that all member states of the AU should join the APRM. So we are looking at universal accession, and in terms of the assembly decision, all member states were supposed to have joined the APRM by the end of 2023. So far, 44 AU member states have joined the APRM out of the 55 AU member states, Your Excellencies. That's our humble submission, Your Excellency, the President and Chair of this session. Thank you.
Thank you very much. Congratulations for the work that you are doing to support African countries. And I think that 43 countries out of 54 countries joining the initiative is a huge achievement. So congratulations to you and congratulations to Her Excellency Ambassador Marie-Antoinette Rose Quatra. We are delighted with the collaboration between the APRM and the PAP. Every time we call on Ambassador Marie-Antoinette, she always responds positively. So thank you, and we must continue this work for the benefits of Africa so that Africa can develop to the level that we want it to be at. Thank you very much. Honourable colleagues, I would like to propose that we take note of the presentation by the APRM. Thank you very much for that acknowledgement. And I would now like to ask the Deputy Clerk for announcements before we close the session. Thank you, Madam Vice President. I would just like to say that the other presentations that were planned for this afternoon, among the presentations that were planned, we have one presentation that is not ready, and we just received a notification from the presenter who was supposed to present on harnessing minerals and other resources for inclusive growth, is unfortunately not available because of an emergency today. So we will arrange a presentation by him on another day. And in terms of the transport presentation, that is not ready, so it will be presented on another day. And the rules of procedure presentation will also be on another day. We will begin tomorrow at 9 a.m. and we will start with the model law on soil management. This will be followed by decisions on by various AU organs on human and people's rights. So tomorrow we will meet at 9 a.m. and we will begin with model law on soil management. Thank you. Thank you very much, Mr. Vice Clerk. And with these announcements, we are now going to close the session for today, and we will meet tomorrow, inshallah, for a continuation of our plenary. Thank you. 9 a.m.